to make mention. Yesterday I make a mention with regard to the amendment was rejected. Matter was posted to 8 milor. Matter was listed yesterday, but could not be reached milor. So I pray can take up specialist at the 2 p.m. Fix is today for hearing milor. By
it comes next week. Nothing will happen. Next week.
2 p.m. milor.
2 p.m. cannot be taken. Same day, pending matter cannot be taken.
It was listed yesterday.
You have said that. Understood. Next.
Monday at least.
Pardon, my lord.
Some different.
One matter.
Thursday found that.
One matter relates to allotment of plot by the BDA. My lord,
Which year? Which year?
2017.
17?
Yes.
Next week. Next week.
Next week.
Yes.
From the list, permitted. It's item 97. Actually, thank you. But the difficulty that my client is facing, an assistant professor.
What you want? Time?
No. I want taken up today may not be like a 97.
We will go by.
Yes, that is why I'm making an unusual prayer. Can it be next week? Then it has the fresh admission, so it can be reached.
It's an admission matter.
Yes.
Perhaps it may reach today.
Sorry. It will be the 97 man. Serial number 97 in the list.
In an admission matter?
Yes.
After notice or before?
After notice.
After notice.
Person is not getting salary. It has been salary has paid. It has been recovered by the university. Even assistant professor. From 2016 is something.
Matter of 2000.
Matter of 2025 because there are inter-department. I don't know any in the fresh any convenient to matter.
On this matter on 20th.
Month. In the fresh.
My lord, I don't know 29.
29. You want time?
After 1 week.
After 1 week. 29. After 3 weeks. At the request of inform the other side.
First up, this is for fresh admission. The petitioner is high school. Is running a high school. And
For next week. Take that.
Yeah.
Item 16, my lord.
Huh?
Item 16.
16. Make use of the mic.
Item 16, lordship.
Yeah.
Due to some personal work, my senior is out of state.
At the request of. Yes. Yes, sir.
May I submit to Lordship? Item number 1. Actually, I am a retired.
Item 1. What I will take up? Yes. You want time? Why he is standing?
Well,
Brother, your neighbor was standing. Person beside.
no.
Yes.
I am a retired reader of political science, and I have a prayer to fix common parameter for placement of lecturers of aided colleges into lecturer of Group A after completion of 8 years and reader scale after 10 years at par with the state-sponsored lecturers. And this case has already been decided in a batch of cases.
Is it covered by the matter?
Covered by.
My lord says retired since 6 years. And now coming here.
Correct. If coordinate benches have already granted relief to similar persons, then you take notice and say.
My lord says representation under Annexure 5 at page 23. It is not, mode of communication is not given, my lord. Let him file another representation so that that can be considered.
Please be permitted. It is relevant to mention that this matter has already been disposed by this, a similar case has been disposed by this honorable recently with a direction to the opposite party to reconsider the fresh application.
Fresh application.
Fresh representation.
If you give fresh representation.
On 9/7 in WBC number 14211.
The subject matter of this petition is substantially similar to the one treated by this court in WP number 14211 of 2025, wherein liberty is reserved to the petitioner, litigant in the said case, to make appropriate application ventilating his grievance, and therefore learned counsel for the petitioner rightly submits that he also should be given such a liberty to make a fresh representation which needs to be considered by the opposite parties. First one, learned AGA on request having accepted notice, although initially opposed the petition, now graciously agrees that if the petitioner makes an appropriate application, there would be no difficulty in considering his claim in accordance with law if all the contentions are kept open. First off, this is appreciable. In view of the above, petition is referred off.
Time limit.
2 weeks granted to make the representation. And if one is made, the same shall be considered within 8 weeks next following. First off, all contentions are kept open. Solicit. Web copy. In all orders, you should write web copy to the exchange.
Deeply obliged.
Item 2.
My lords, this is not assigned, my lords. Service settlement.
Registry to reclassify the matter after verifying the records and post it before roster bench
Next thing.
at the earliest.
Item 3.
I cannot fix time for the other judges.
May I please your lordship, my lord?
Yes.
Limited prayer of the petitioner seeking a direction to the opposite part number 2 and 3 to supply the certified copy of the OEA case number 1236 of 1970.
OA case number.
Oh,
What is that OA?
Orissa State Abolition Act, there is an
Act.
act.
What
It is
copy?
assigned to other bench, OE matters.
Assigned to other bench. But he wants consideration.
Consider. So,
Okay. The short grievance of the petitioner is as to non-consideration of his request for furnishing of Orissa
my lord, certified copy in a particular
certified copies of
case number,
OEA.
order passed in OEA case number 1236 of 1976.
70.
First, correct?
1970. OEA case number.
You have written in para.
Anyway, which is that correct?
Yes, yes.
This one you tell.
1236 of 1970. 70.
1970.
70.
But rectify it in the papers then because you have written 75.
76.
76. Sorry. First one. Learned customer. Although it has been wrongly mentioned, although the description is wrongly made in the pleadings. First one. Next paragraph. Learned AGA on request appearing for the opposite parties agrees to instruct his clients to look into the grievance of the petitioner in accordance with law and in a time-bound way if all contentions are kept open. First one. This is appreciable. Next paragraph. In the above circumstances, petition is disposed of. Petitioner to make a fresh application within 2 weeks, and if one is made, the same shall be considered favorably within an outer limit of 3 weeks. Next following. First up. Next paragraph. Open to solicit. No course. Web copy. Yes.
Item 4.
Yes.
Here I have got
Why you, Mr. Government Advocate?
Well,
Even to get copies of the records, should they come to High Court? You should advise your client. Yes, sir.
here I have got a way bridge. I've got a mine. I've got a way bridge, which is owned, maintained, and operated by me. Now, when the moment the truck moves out, I pay 1 rupee to the state government per ton. Now, all of a sudden, the government demanded that you pay 35 rupees per ton, 25 rupees towards cost of maintenance, and 10 rupees towards cost of staff deployed there. That is the government staff. So I replied that, sir, I don't take a staff. I maintain myself. My staff are employed, so I'm not liable to pay 10 rupees to salary component of government employees. To that, there was no response. Annexure 1.
Annexure 1, let them take a decision.
No. They again demanded. Annexure 3 is the second demand.
Correct.
No.
You have given representation now.
No. After the representation, they didn't bother. They said, we'll stop transportation. All over the country, they suffer. So I deposit under duress. After deposit, I made an application that, sir, you please refund my money. You have paid me under, I paid this under duress.
You take notice, press.
My lord.
You take AG requested to accept notice, issue emergent notice. First of AG is requested to accept notice. Post this matter week after next, since it lies in a narrow compass.
Would I give two other numbers? Two different?
Yes, give that.
I'll give it
All
as
this, but along with WP number, sorry, Susans.
Your lordship granted 4 weeks time.
2 weeks I have given. What is there after all? There are many judgments which hold in your fixation of tariff and other things are a matter of state policy. Therefore, look into that also. But there are some rulings which say it cannot be that arbitrary. It should be on a quid pro basis. Okay? Look into that judgment.
No. Here it's not.
Anyways, we'll not argue now. We'll now only.
Everything is mine.
Next.
Item 5. This is a case, my lord. My lord, the petitioner is a retired political science reader. My lord, he was retired on 31/8/21, my lord. He was denied with the pension, my lord. And his
Pension is not paid.
paid, my lord.
Why not paid?
My lord, because, my lord, they have stated that the criminal case is pending. So, but that has been already ended in final form, my lord.
You brother? Who pays for that?
I appear for the Vigilance Department. In fact,
He says he is acquitted.
My lord, they have also, my lord.
no, not acquitted, lords. One thing, lords. Your lords, the director Vigilance has not been employed as a party.
You
lords.
came. It appears you came early.
Exactly.
Kindly be seated. We'll take this matter of 10 minutes. After 10 minutes, you can do that. Sit down. Sit down.
Thank
Not
you.
have tension.
Thank you.
Yeah.
Item 6.
Item 6, my lord. After completion of 30 years service, my lord, person is not allowed, my lord, third MSP benefit as per the decision of your lordship's decision, my lord.
My lords, there is no cause of action, my lords.
Why?
My lords, he relies on a circular of 2017. But he has not made any representation or
You make representation and you consider.
Similar, your lordship's order.
Take that. You should at least make one representation. Then if it is not considered, you should come to, we should treat this matter this way. Yes, this hold on. Everything being self-calculable.
My lord, in that, pardon, my lord, in that matter, my lord, the previous matter which I have submitted before the certificate copy, name of advocate is wrongly tagged documents.
You give that chief, he will,
Yes.
our Samal Saab will look into. Okay? Yes.
Item 7.
7 kindly taken up next week, let's
3 weeks at the request of.
Let's see, then, my lord, sir, I will place some judgment one, therefore I couldn't get it today. Next week, let's
Next
kindly.
week we have difficulty. The calendar is heavily
So let
loaded.
me place my case. Kindly permit me then. That's
Next week, not next week.
grateful. Let's
At the request of.
Item 8.
I think taken up 2 weeks, my lord. Which up to
4 weeks at the request of.
Item 9.
Item 9, my lord, this is second round of litigation, my lord. Second round of writ petition, my lord. Petitioner's prayer for grant of, petitioner is a retired reader, my lord. His prayer for grant of UG scale of pay has been rejected by Annexure 7. Annexure 7, page 44 is the rejection order.
Why it is rejected?
My lord, on the ground that page 44, my lord, second part, and whereas the documents.
Go to 44. What is the ground which they
Whereas the documents as stated above were duly received and examined, and it is found that the petitioner has acquired 45.38 in post-graduation, which is much less than the required
55%.
percentage for grant of UG scale of pay.
Correct.
I have secured 45.38, which is less than 54%, my lord. I admit that.
Yeah.
My lord, have a glance to the petitioner earlier, by annexure 2, my lord, he had filed a writ petition. At that point of time, it was OJC number 2560 of 1990. There, my lord, this honorable court, by judgment dated 8/3/1991, starts from page 18. My lord,
What it said?
It says that the petitioner is entitled to get UG scale of payment.
How, without 55%, how can that be given?
Because there is a relaxation clause, my lord. Page 25, my lord, have a glance.
Relaxation clause. Where is that?
But that relaxation clause, that I have not enclosed, but the judgment is in my favor. That was my case. I had filed.
That's all right. These benefits are granted on normative basis. The minimum requirement, one of the 3 requirements, he should have secured more than 55%. You have not. What is wrong in that?
But this honorable court has observed that and has directed and has observed that I am entitled to get UG scale of pay.
That's not correct.
But the order is to be implemented.
That's all right. That order, we'll mention that also now. The order is that prima facie itself you are entitled to, because otherwise it would have straightway said, give him that scale. That order is not made.
But since consider was thereafter, page 25, my lord, there was a direction, my lord. There was not direction to consider.
Consider. Otherwise, court itself would have directed.
My lord, page 25, my lord, have a glance. Page 25. The same was qualified by a proviso if the selection committee is of the view that research work of the candidate is evident either from his thesis or from his published work of a very high standard, it may relax any of the prescribed qualification. Thus,
did you seek for relaxation?
Yes, my lord.
Show that.
My lord, that relaxation clause, my lord, I have not.
Clause is all right. Did you seek relaxation, saying that please relax and consider my case? That is not your case. But because normative, these benefits are normatively governed. Court cannot say you are entitled to, you are not entitled to. It is for the committee to decide these things. That is the reason why court said consider his case.
No, thus it is not possible to hold that the petitioner was not eligible for appointment basing on the mere fact that he had secured less than 54% of mark, as the same could be relaxed as mentioned in the proviso.
Could be relaxed, but that has not been relaxed.
Therefore, this honorable court has directed that the petitioner is entitled to receive the UGC scale of payment. There is page 25.
Notice. Issue emergent notice, which is that who appears for whom?
State.
AG?
Yes,
AG?
yes,
for all
yes, my lord.
Issue.
Two opposite parties, my lord.
Notice. Learned AG is requested to accept notice in as much as there is some observation in the earlier round of litigation by a coordinate bench that is arguably in favor of the petitioner. Sorry. Next.
Item 10. Item 10.
None appears for the petitioner. Call after 4 weeks.
Item 11.
Lordship permits, I'm sorry, but and that item 5 blocks.
Number 5.
That your Lordship wanted me to stand up after 10 minutes. So the short matters. My Lord, your Lords, before I apprise your Lordship about the.
He says, I have been acquitted in the criminal case.
That's not correct. It's not acquitted. Vigilance case was initiated. And it was after investigation, no charge could be established and ended in a final form.
No charge was
if Lordship turn to flag B.
No, I will believe you.
Yeah, members.
Whether was there any disciplinary proceeding against him?
That you, my Lord, will appraise your Lord. So far, that vigilance case initiated against the petitioner.
What happened to that?
Ended in a final form. After investigation.
Ended in
a final form that they could not get in materials.
That means it ended in acquittal type. Well, he is exonerated.
In fact, that final form was filed before the Lord and Trial Court to accept. That has been filed with the Lord and Trial Special Judge Vigilance.
No order is passed on that.
No.
We'll request that magistrate to pass that order with the right of. Listen to the court.
My lord, now.
Listen to the court.
My lord.
And your lordship can produce a flag A. That's the instruction from the Vigilance Department.
Now that it is like B report, saying that that no case is disclosed.
Final form.
On that report, court has to make an order in terms of apex court decision in routine.
I'm waiting protest petitions.
That kindly see. You do not remember the decisions.
Yes, your lordship is correct. No? That is this.
I tell so that you will know the law.
Yes.
It becomes easy. Brother, now you are saying acquittal. It is not a case of acquittal. Matter is still pending. And they have filed a report. It's called B report in Karnataka. I do not know.
This is final form. Final report.
173.8. 173.8 report. Yes. Therefore, we will direct the magistrate to pass order on that report. In terms of apex court decision in Rupen Devol Bajaj versus KPS Gill.
Only thing, my lord, only submission, my lord, only in Rule 7.2 of the pension rules already amended that it was provided that provision has been inserted that the regular pension and gratuity and other retirement benefit can be sanctioned if magistrate has not taken cognizance on the charge sheet. Therefore, my lord, he is entitled for the pension.
The amendments introduced 2025 itself.
That's all right. That such amendments are always retrospective because they are beneficial employment. Merely because some case is pending. Where is the power to withhold?
Yes.
Show your
unless until court takes an order taking cognizance.
You show your rule that pendency of a criminal case is a ground for deferring the payment of terminal benefit.
No, I'm not to give the pension, my lords. My learned friends is to give.
Brother,
Well,
whether rule provides for withholding of pension on the ground that criminal case is pending?
when it's in fact, copy is not with me. It was not.
He has been served, my lord. They have taken
Third one more copy.
my lord.
Okay. Learned AG is requested to accept notice for with respondents.
If lordship permits.
All the respondents.
May serve.
Vigilance.
Vigilance.
I've got the copy, my lords.
You appear for.
My lords, I appear for the Director of Vigilance, who is not a party here, but last bench, the Honorable bench passed the orders. I filed what I suggest, my lord, I filed an affidavit pursuant to this Honorable Court order dated 25/7. Yes, my lord. On 25th July 2025, this Honorable Court passed an order directing me to file an affidavit, my lords. We have filed an affidavit e-filing on 8 August 2025. Inadvertently, it could not be tagged with the files. Let the office verify and tag with this one.
No, I'm asking. Pension is not a bounty.
Exactly.
Unless rule authorizes,
Correct.
you cannot withhold it.
Correct.
Even if criminal case is pending.
Yes.
Because criminal case with kinds of judges like me will take 25 years to get completed. You mean to say he should die?
This is correct. And my lord, keeping in mind lordship views, lords, the state government has come up with an amendment, lords. Amending the pension rules, Rule 7.2, lords, that it says, my learned friends holding that copy, my lords.
Unless cognizance is taken.
You can't say this pending, and for which the pension is not being paid. That plea is no more available in view of the fact in this case also. So far,
where is the cognizance? Protest petition is filed.
Correct, my lord.
Protest petition has not been filed yet.
No.
Final form has finished.
Final form in your favor.
Saying
that alone protest petition.
Yeah, exactly. Correct.
Even when the 81 rules.
You consider you have made representation.
My lord, my case is rejected after
rejected. You take notice. Learned AG is requested to accept notice for the respondents.
And let office verify the affidavit filed by
you appear for whom?
I appear for the Vigilance Directorate, which is not a party. But pursuant to the lordship orders, I filed an affidavit. Let it
order was made against you without a party.
Not against me, expecting me to file an affidavit to enlighten what is the stage of that vigilance case. So that
you implead him also. Learned counsel for the petitioner on the direction of this court has arrayed Vigilance Director.
Director of Vigilance.
Director of Vigilance as a respondent number.
I think
OP number
6 over.
OP number 6. First up. Learned panel counsel.
And the affidavit filed on behalf of the maybe tagged with the file.
Learned panel counsel Shri so and so.
Whatever.
Accepts notice for the newly added OP. Amend that. Amend that. And amend it in their petition also.
And the affidavit filed by me may be tagged.
Has amended the cost title with leave.
And the affidavit filed by me may be tagged to the file.
Affidavit filed by newly added party be tagged with the file.
On 1st August 2025, affidavit E-filed.
Affidavit filed by OP number 6, now added, comma.
On 1st August.
Date filed on 1/8/2025 be tagged this. First matter lies in a very narrow compass and therefore call this matter on 21st. And thoughts. Bring that judgment that Rupen Mehul Bajaj versus
IPS.
95 Supreme Court or 96 Supreme Court. Yes.
Item 11.
And please, Your Lordship. The matter relates to promotion, Your Lordship. If the annexure 4 is pending for the authorities, that may be considered, Your Lordship.
Promotion to from which cadre to which cadre?
Promotion to Sebab to head Sebab, Your Lordship. Sebab to head Sebab. That is the
to head clerk.
Head Sebab, Your Lordship. The Department of SCST, Your Lordship. There is this school, Your Lordship, where the post are Sebab, that is the assistant teacher, and the head Sebab is the master, Your Lordship. As per gradation list, Your Lordship, I should be
Third grievance of the petitioner is as to non-consideration of his representation dated
2/5/2025, Your Lordship.
2/5/2025, wherein he has sought for his promotion from the post of Sevak to head Sevak in the subject institution on the basis of his placement in the gradation list. First time. Learned counsel for the petitioner argues that when a representation of the kind is given, the employer is bound to consider it in accordance with law. And that having not happened, this court should come to aid of the petition. First, learned AGA, correct? Yes, AGA, appearing for the opposite parties, having resisted the petition, resists the petition, contending that promotion cannot be gained as a matter of right, there being several parameters, and therefore petition should be rejected. First off, having so contended, now he graciously agrees with the suggestion of this court that he would instruct these official OPs to look into the grievance of the petitioner as has been aired in the subject representation within a period of 8 weeks and inform result of such consideration to him as well. First off, all contentions are kept open.
OP2, Your Lordship. OP2 may be directed, Your Lordship. Pending
Jurisdictional.
Yes,
Item 12. May I please, Your Lord?
Instruct OP number 2 like that.
May I please, Your Lord? Sir?
Yes, sir.
My Lord, the petitioner applied for the post of associate professor in the mechanical engineering, my Lord, and his application has been rejected on the ground that the petitioner has not filed the no objection certificate from the employer, my Lord.
Employer?
Yes, my Lord.
Which employer?
Which I am...
Earlier.
Yes.
Earlier employer has to give the no objection.
That is the only ground, but my Lord, I will file an undertaking before the authority that I will file it, but that has been rejected and by the annexure 2.
Which rule requires NOC?
NOC, my Lord, kindly see page 17. That is the general instruction to the candidate, serial number 9. Running page 7.
For recruitment or promotion?
It is for recruitment, my Lord. Running page 17, my Lord. Clause 9. Candidate.
Within what period it should be produced?
That at the time of filling the form, my Lord. It is a online application form. They said, my Lord, that at the time of filing the application form, you have submit all the documents, my Lord.
You are already in employment now.
Yes, my Lord. In another organization, they said in the clause 3, my Lord, clause.
I only asked you.
Yes, my Lord.
You are still in employment.
Yes.
You will go on telling the story. Who needs the story? One by one we shall.
Yes,
go.
sir. Yes, madam.
You are in employment.
Yes.
And for your appointment, NOC from your present employer is needed.
Yes, madam.
That is one of the requirements.
Yes.
That should be produced in a particular time period. It's there. But you are not.
But my lord, I am only applied for the.
When did you apply?
Applied, my lord.
When was the notification?
Notification, my lord, 12/2/2024.
12/2/24.
For my lord.
You applied for NOC when?
My lord, I not applied for NOC.
But how you will get NOC?
But my lord, I applied for the another organization for the post of associate professor, my lord.
That's all.
Yes, madam.
But question is, what all needs to be produced? Which is that? Take that.
Yes, my lord, page 17.
17.
Yes, my lord. 17, clause 9. Candidate should produce 1 service certificate and character certificate from the heads of the institution where they are working, indicating date of appointment, present post held, present pay scale, allowance if any, and the date of next increment. 2, form 16 of the period of
Before interview.
Yes.
Shortlisted.
Yes,
You
my
were
lord.
shortlisted on which date?
My lord, I have been shortlisted on 31/2/2024.
31/2.
24, my lord.
31 February. You are looking at a new calendar.
No, my lord.
Not Gregorian calendar.
No, my lord.
My lord's application should be filed within 1/3/2024 to 31/3/2024.
31.
That very page 17, clause 12. Incomplete application form, if
Will not
any,
be entertained. The 9 requires production
of NOC.
Shortlist is made on which date?
Shortlisted, my lord,
Unfortunately, February.
No, it is
29 once in.
No, it might have 31/3/2024. Page 20, my lord.
3/24 you applied for.
Yes, my lord. It's a page
That
20.
is, a shortlist is 31/3/24.
Yes, my lord. That is
The
the
application was rejected.
Application was rejected.
My
On the
application.
ground that you had not produced this.
Yes.
What to?
That is, my lord, on 18/6/2025.
Because Supreme Court said, unless all documents are produced, and the clause 12 says incomplete application will be rejected. What can be done? Object is, already you are in employment.
Yes, ma'am.
We are 140 crore people. Other freshers should be prepared that way. That's the object.
But
It's
my
not
lord-
that you are without employment.
No, that.
But there are lakhs of people without employment.
If, my lord, I take a no objection from my earlier employer, my lord,
No, wait,
then
that-
my
that
service will be in stake, my lord.
What
Therefore,
can-
my
what
lord.
can- what
That
can-
is the-
That's the rule. Unless you challenge that itself.
And at present, my lord, I am jobless, my lord. I am.
Why? You were in that job.
Yes, I left that job, my lord.
Why did you leave? It's your fault. Why did you leave? Which fool will leave the job?
Where any contractual basis, my lord, therefore I left that job.
Okay. Can anything to be done? Because if we do in your case, that becomes a precedent for rest of the cases.
I know.
Everybody will say, brother, Justice Dixit, you gave order other day. We need
No, my lord.
Why not to him?
No, that where I cannot made, my lord, before this.
Right. Petitioners' candidature for the appointment pursuant to recruitment notification dated 12/2/2024 has been negatived on the ground that he failed to produce the requisite certificates from the previous employer in terms of instruction number 8,
9, my lord.
9, followed by 12, which are part of general instructions to the candidates in the very same notification. First off. Next paragraph. Learned counsel for the petitioner. Kindly be seated. Learned counsel for the petitioner argues that the information bar such NOC and such other documents are to be obtained from the side of employer, and he could not secure them despite making some efforts, and therefore the time for production of the same should be relaxed and a direction be issued to the opponent parties to consider the case of the petitioner for recruitment. First off. Next paragraph. Learned AGA on request appearing for the OPs opposes the petition. Pressing into service Rule 9, Instruction 9 and 12, which read as under. This is the page number from page 17. First off. He also, next paragraph. Learned AGA also tells the court that these instructions are not put in challenge and there is no provision for relaxation either, and therefore if relief is granted to the petitioner, it would lay down a dangerous precedent for others to follow. First off, so contending, he seeks dismissal of the petition. Next paragraph. Well, some sentence you can put. There is lot of force in this submission. First off, in the above circumstances, petition is liable to be rejected, and accordingly it is. First, however, liberty is reserved to the petitioner to make an appropriate representation to the concerned authorities if there is any provision for relaxation or there is any past precedent where relaxation of the kind has been accorded. First off, if such a representation is made, the concerned authority shall consider the same on a war footing. First off. Okay.
Obligement.
Item 13. May I please?
Yes.
Petitioner was continuing as an assistant professor since 2019. Challenge the advertisement made in 12th of 24, my lord. Filling of the regular post. Similar matter day before yesterday. My lord, have already. Sir,
what we have done.
My lord, have issued notice and given they can proceed with the selection, but no final.
Issue notice. Learned AGA appears for
UP1.
Notice to the rest.
Respondent to
first off, interim order as in WP number so and so.
Well, it's the advertisement of year 24 February, my lord.
No, let it go on. I am not halting. I am not halting. All right? We have copy. In every judgment, tell the authorities to act upon. Writ proceedings are on web basis. Orders are certified copies needed. They will take 6 months.
Website copy.
Call along with.
Item 14.
None appears. What is this case?
Retired on 31st January 25. And they asked prayed for release of pension and he has not filed anything, no representation, nothing.
Why representation? It's the duty of the state government to put the pension in the pocket of the retired employee.
He's entitled
Take
to get
notice. Take notice. Emergent notice. Learned AGA is requested to accept notice for the respondents. Call it in the second week of September.
Item 15.
May I please, your lordships?
Yes, sir.
The innocuous prayer, my lord, to direct that opposite but not 2 and 3 to dispose of the department proceeding initiated against 4 and 5 respectively.
How long it has been pending?
Well, the department, you lordship may kindly see Annexure 9.
Kindly see the petitioner, the locus standi of the petitioner.
Who are you?
But on my behalf, my lord, I am harassed. Your lordship may kindly see the...
who are you? Are you a person who is in the disciplinary proceeding?
At my instance, my lord, though I have been harassed, my lord, my instance, my lord, department
You
proceeding.
are the complainant?
Yes.
On your basis, the
Yes,
TDE
yes,
is
sir.
going on.
Yes, sir.
TDE was initiated when?
But it is initiated whenever Annex 9 is concerned. It is initiated on 5/6/2024. 28/3/2024 against opposite party number 4. And at the direction of this Honorable Court, the department proceeding is initiated against OP number 5.
On the basis of your complaint?
Yes.
He is a complainant.
I am the complainant.
But generally, how many years you will take to complete? What is the allegation against him?
Allegation will also make kindly see Annex 4 for him.
I am asking you.
My lord, the petitioner being a blind teacher, he is harassed. His pension, even if direction was given by this Honorable Court and State Administrative Tribunal, his pension was halted for many years. And also, my lord, bribe was asked for.
Okay. There is a judgment of Apex Court which says all departmental proceedings should be normatively completed within 6 months. You can't keep it for years. He's a blind man. And Francis Bacon, a great philosopher of England, said, revenge is a wild form of justice. Now he has been suffered. So he was made to suffer. Person with disability. All right. He has given representation. You have initiated inquiry. You cannot keep the inquiry pending for a 5-year plan. It is not a 5-year plan. Panchavarshika Yojana nahi hai.
Only in 24 it was initiated.
It was 28/3/2024.
Yes.
How many more months you need? You instruct your client to accomplish it within 3 months.
Yes.
The short grievance of the petitioner, who happened to be the complainant against private respondents herein, is against long pendency of a departmental inquiry, which he says is in contravention of right to speedy justice. First off, next paragraph. Learned counsel AGA appearing for the OPs opposes the petition, contending that the inquiry is instituted only on 28/3/2024 and regard being had to workload mounting on the shoulders of disciplinary authorities in the matter of administration being heavy, no time limit can be prescribed for disposal of the deed. First off, this is a bit difficult to agree with. First off, a departmental inquiry cannot be a 5-year plan. First off, Apex Court in a canon of decision has observed that all departmental inquiries ordinarily have to be accomplished within a period of 6 months, subject to all just exceptions into which argued case of the petitioner does not fit. First off, next, in the above circumstances, petition is disposed of, directing the accomplishment of the subject inquiry within a period of 4 months, all contentions of the parties having been kept open. One sentence you have to write down. Notice to private parties is dispensed with, since no coercive order is being passed against their interest.
Two departments.
I beg your pardon. In case of private party, opposite party number 4, the Department of Proceedings initiated in March 25.
March 25.
Yes. And then,
anyway,
yes.
We are giving you 4 months.
No, you're
4 months will be 7 months. So 6 months is the rule.
So your Lordship made a direction that the observation that the proceeding was made in
25 it should be.
5, so far the opposite party number 4 is concerned.
Yes. Another is
24. That's good.
Right down. In March 2024 and March 2025. You can write.
Against opposite party 4 and 5 respectively.
I want notice to distance somewhere in Item 17.
Granting it's a domain of state education tribunal. He has to pray for approval and release of granting. That is
It's a matter of RSU matter. Item 17.
17.
Pass on.
No. Pass. Take this.
Item 18. May I please your notes?
Yes.
Well, here, the Mahanadi fulfilled a public sector colliery. It's a coal company. He has taken a NOC from the Central Groundwater Authority.
Central Groundwater Authority.
But the MC Mehta case, Supreme Court has stated that the Lordship just it's a short note. I am giving copy. Your Lordship kindly see para 9.
What he says?
But it says that central government in the Ministry of Environment and Forest shall constitute Central Groundwater Board as an authority under Section 3.3 of the Act, means Environment Act.
Water prevention of water pollution.
Yes. No. This is 3.3 of the Environment Act. Under the Environment Act, because it relates to groundwater of the mines. So therefore, it has to be done by the Central Groundwater Authority. And they are the authority who gives the NOC. No objection certificate, because I have to
Not the central government. Not any other authority.
No, because that authority has the power and I have to give application and I have to deposit money and they consider and they give. And that is because it is only to dewatering. Because in coal mine, the waters are natural phenomena, water is accumulated. So it is, he has not to do any other thing, it has to dewatering. For that, you have to, because it will, how it has to be done, because NOC has to be given by the authority. And that is this.
Who are you?
Well, I am the Mahanadi Coalfield, a public sector colliery. And I have the mines. So I have taken this NOC.
It's not a matter relating to environmental law.
No. This is now they have demand under the Orissa Irrigation Act. In supersession of, because once, now my case is, once the Central Ground Authority comes in, Section 3.3 comes in of Environment Act, Irrigation Act ousted.
Because state act.
Yes, it's a state act. And that is related to entry 12 of the list 1. Once the entry 12 of list 1, Environment Act, and 246(1) is that to the exclusion of 2 and 3. So therefore, it will never be the Orissa Irrigation Act or rule. It has no application. I am not challenging that virus. I am challenging the applicability, because which act, who has to be applied.
Even the conflict also may not arise at all.
No, not at all.
Because they are under different heads.
Yes, different heads, and this is Union List 1. And once 1 is 246(1), it is exclusion to, because it's subject to 2 and 3. So therefore, did not. So this is clearly a case where only the question of this has to be seen. And now they are unjustly, they are demanded under the Orissa Irrigation Act, treating as a government water source. And this cannot be a government water source, because this is a colliery vested under the CBA Act. One CBA Act, Miller, I have given Annexure 1. Kindly read Miller Annexure 1.
Let us issue notice.
Yes. And Miller, the interim order for this non-payment, I should not pay. No coercive action for the demand.
You deposit that money in the registry.
Miller, that's only 30.
How much money?
Miller, without any notice, nothing. Without any notice and nothing. I am a central government.
Without jurisdiction?
And I am wholly without jurisdiction. No natural justice followed. And I am a central government. This is a part of
government organization.
Yes, this is part of the Coal India. Mahanadi Coalfield is the subsidiary company of the Coal India. So this is nothing, I'm the here.
Don't take coercive action.
Yes.
2 weeks.
Yes.
Come out your objections. will hear and dispose of the matter.
Yes.
Very short matter.
Yes.
Whether it falls into your Irrigation Act,
Yes.
or it fits into the other central law.
Yes, central act, central rule, that is the rule that has been
Central
framed.
law.
Yes.
Central law.
Central
Because
law.
under 246(1),
Yes.
exclusive prerogative in respect of list 1
Yes.
is with the center.
Yes.
It appears that way. That's subject to some extent. Like Tulloch and Karunanidhi versus Union of India. There are many.
Yeah, many cases, my lord, that.
In such case, with due respect to my learned senior, the Union of India should have been a party to this.
Why?
No, why?
The grievance is against you.
They have given cases.
Against me, because your lordship and he's relying that the coal wearing act, CBR. Coal wearing act.
Yes.
Yeah,
Coal wearing
you have to
is
question.
That is the
Suppose,
vesting order.
Suppose if he has a grievance under the provisions of IPC, Union of India should be made a party.
No. But this is interrelated matter.
No,
You take up that contention. You take up that contention. We'll treat it when matter we consider for issue emergent notice. Learned AGA on request accepts notice for the respondents. First off, next paragraph. Learned counsel, panel counsel. Are you panel counsel?
Mr. Sanjit Mohanty, senior advocate.
I'm sorry that I will not be knowing names of many of you because I am a fresher. Learned senior advocate Shri Mohanty, appearing for the petitioner, submits that there cannot be demand of the impugned kind in as much as the subject matter essentially fits into a law enacted pursuant to entries in the union list in terms of Article 246 of the Constitution of India, and therefore there should be stay of coercive action of recovery. First, there is a prima facie case for grant of reprieve, at least for a limited period, amount involved being huge, and the petitioner being none other than an entity of the central government. After all, first off, petitioner will be always available with funds to make the demand in question good should the petition fail. First, next one, in the above circumstances, the respondents are restrained from taking up any coercive action pursuant to impugned order for a till further till next date of hearing. First one, call this matter in the first week of September 2025. First one, web copy.
The urgent copy.
Web copy. We are saying parties to act upon the web copy. Oh, yes. Statements. 19. One sentence you are there. Mr. Mohanty pressed into service the apex court decision in MC Mehta versus Union of India. India. Manu SCOR. Just look at it. In support of this contention.
SM 19.
Yes.
And challenging the order of rejection. Petitioner was appointed as a Ganashikyak in the year 2008.
Similar matters.
I'm giving the notice has been issued.
Issue notice. Any entry order is granted?
No one. Only
call learned AGA is requested to accept notice for the respondent. Call this WP along with WP number. Call this case WP.
Item 20.
May I please?
Yes.
This matter involves, Your Lordship, the three petitioners are there. All of them have recruited in the post of demonstrator. Lordship, I may draw your kind attention to Annexure 4, Your Lordship, page 47. There's a true type copy also given.
What is this?
There's a notification, there's a letter issued by the Ministry of Human Resource Development government. What has happened this prior to 1986, there was
revision of pay scales.
Revision of pay scale in terms of the UGC, Your Lordship. What has happened?
Did you give the representation?
I've given the representation. They have rejected my representation. That is at annexure.
Rejected on the ground?
On the ground that this, I am not entitled to get a at par pay scale of UGC. I'll cite, Your Lordship.
Why?
Because I have been recruited post 1986. There is a cap given by the UGC in this particular notification, if Your Lordship may see at page 48, Your Lordship.
Any cutoff date is fixed by
Your Lordship. Your Lordship. Miss, I may place, Your Lordship, page 48, the last paragraph, Your Lordship.
To take notice similar matters, we have already issued notice. Issue emergent notice. Learned AG requested to accept notice for
Lordship,
one and
4. Emergent notice to the rest.
Grateful.
Item 21, matter relating to RSCP matter. This matter can be taken up next week.
3 weeks.
Next week matter. Similar matter.
Similar matters are posted next week.
Yes, madam.
Ashok is requested to accept notice for the respondent. Call this matter next week when similar matters are posted.
Item matter.
This is a matter of pension. But at the outset, I will only submit my lord. There is a mistake on my part in the petition itself. Shall I be permitted to withdraw to file a better application?
All right. Learned counsel for the petitioner fairly submits that he may be permitted to withdraw the petition with liberty to reframe the petition and present freshly. First up, WP is disposed of with liberty as sought for.
Item 23.
May I please, Lordship? Because this petition was before this Honorable Court earlier, and his case having been disposed of by the order on Annexure 10, direction was made to OP number 1 to consider his case that is pending before under Annexure 8 and pass necessary order. And pursuant to that, the case of petition having been considered, it has been rejected by the order on Annexure 11. Now challenge has been made.
What was the representation, brother?
Annexure under Annexure 8, the presentation, he claimed placement of his placement lecture group A and reader essays at par with the selection board sponsored candidates. And this issue has already been decided by this Honorable Court by the judgment on the Annexure 9 series. And in terms of that, direction was made that his case be considered and decision be taken.
Why they rejected?
Now they have said that in one case the matter has been carried to Supreme Court, though we have implemented the order. And in another case, we have not gone to Supreme Court, we are thinking of going to Supreme Court. But the order has been implemented, benefits have been extended, they have gone to Supreme Court at a point of time.
Let him take notice. AG is requested to accept notice for response number 1, emergent 1 and 2, emergent notice to 3. Any other matter of similar nature?
The second one is just
same.
24.
23, 24. Got together.
Item 25.
May I please, Lords?
Yes.
The petitioner, while in service, has been convicted in vigilance case. And after conviction of vigilance case, he preferred the criminal appeal. In appeal, it was admitted and sentence has been suspended and he has released on bail. But due to the conviction in criminal cases, his provisional pension has been stopped by the authority under Annexure 3, Lordship.
But he is convicted.
But in criminal appeal is pending, my Lord.
Criminal appeal is pending, but sentence is stayed. Conviction is not stayed.
Conviction, sir. Sentence has been
justified. In Navjot Singh Sidhu versus some state, the apex court discussed what is difference between stay of conviction, stay of sentence and conviction. In appeal, your liberty might have been enlarged
because
of stay of suspension of sentence. But that does not take away the guilt that has been attached to you after full-fledged trial.
Rule 66 of Odisha Civil Service Pension Rule says that in case of the conviction is affirmed in appeal, whatever the provisional pension paid, that can be adjusted in final pension.
Question is whether pension can be given to a person who is convicted by the court.
Yes, my lord.
No, it cannot. You show that rule.
Well, Lord, you can see.
During pendency of a criminal case, yes, I agree. But once you are convicted, and still you are saying that you should be paid the pension, how that?
Because of pendency of criminal appeal, my lord.
Appeal does not result into suspension of the conviction.
No. But I pray till disposal of criminal appeal, provisional pension may be granted.
No, cannot. Right now.
Well, Lord.
The short grievance of the petitioner is as to not sanctioning and release of
the rule for a moment. I will satisfy Lord.
Read. There are any number of Supreme Court judgments. Yes, read the rule. Even if he is convicted, he should be given merely because appeal is filed.
No,
appeal is not by the state, appeal is by you.
Yes, my lord. Provisional pension can be adjusted if the appeal is dismissed.
Right now.
Let's see, the Rule 66 of Odisha Civil Service Pension will provide that when a departmental or judicial proceeding are pending against a government servant on the date of his retirement, the government servant shall be paid a provisional pension equal to the maximum.
It is not pending.
No, it is.
You are convicted.
Yes,
conviction is not stayed.
The conviction has not been stayed.
The short grievance of the petitioner is as to non-sanctioning and release of provisional pension.
Well,
on the ground that
can adjourn for a moment.
I have already held that way. The Appeals Court has affirmed it. On the ground that he has been convicted and sentenced in a criminal case involving moral turpitude. First, learned counsel for the petitioner vehemently argues that under the provisions of Orissa Pension Rules 1992, even during the pendency of a criminal proceeding, the state can sanction the provisional pension, and therefore the petitioner should be given that benefit. First off. Next paragraph. Learned DGA, on request appearing for the respondents, opposes the petition, contending that although a particular rule in the 1992 rules provides for sanctioning of provisional pension to an employee against whom a criminal proceeding is pending, the rule does not provide for the same benefit when the employee is convicted and sentenced for an offense involving moral turpitude. First off, he also points out that petitioner, having been convicted and sentenced, have carried the matter in appeal, wherein he has secured an order suspending the sentence and not staying the conviction. First off, the apex court in Navjot Singh Sidhu versus so and so has discussed the matter, discussed the difference between stay of conviction and sentence and stay of sentence per se. First one, that logic applies to case of the petitioner. First one. Next one, in the above circumstances, petition being devoid of merits, he is liable to be rejected, and accordingly it is, courts having been made easy. First one. However, in the event petitioner succeeds in the criminal appeal, then it is open to him to make appropriate representation to the answering respondents and seek pension in accordance with law. First.
That is Rule 66 of the 92.
Rule 66 of 1992. Quote that. Just. Okay. Next.
28.
It's a case under, well,
Yes, sir.
approval of the project under the State Disaster Management Fund. So, my lord, the guidelines of Annexure 1, implementation of the guidelines concerning page 23.
What is your prayer?
My prayer, when these separate and specific guidelines issued by the government with regard to implementation of the State Disaster Management Fund for utilization of project in different affected area, in spite of the order under page 65, earlier order, the 65, the writ petition stand disposed of within direction as appropriate to be complied with by OP number 1, followed by decision at the earliest preferable within a period of 4 weeks from the date of receipt of the copy of this order, until such time issuance of work order in respect of the works to be kept in abeyance. So, my lord, in spite of the order, the impugned order Annexure 5, page 66 and 67, when the specific guidelines with regard to implementation of the scheme is there, violating these specific guidelines on applying Odisha Relief Code, page 67, our project rejected. So,
your project is rejected.
Rejected. So, we are the affected, different panchayats and gram sabha, the projects, schools and institutions are affected. Houses are also damaged. So
in Dana. You take notice.
No, Annexure 5 is the final order.
Five?
Yes, Annexure 5.
That is
and given the reasoning why they have rejected, they have quoted the Odisha Relief Code, para 76 and 77. I'll take notice about it.
You take notice?
Yes.
The DG is requested to accept notice for respondents. Post in third week of October.
Well, our project shall not be, because it is sent to the district level committee, but the government have not approved it. So our project be protected.
How?
Because some of the project are
all
approved.
Disaster management policy. Can we halt them?
We are not halting. Various projects are sent to the district administration, and district administration out to pick and choose method sent it to government for approval. So our projects are left out.
On 20th of August 2025. Let us.
May take issue miscase notice I can, because we apprehend our projects may be diverted or left out
for consideration.
Yes.
20th difficult, brother. We will have it on 26th. 26th.
My lord.
Lordship.
Yes.
Lordship is for RSCP benefits. Lordship, item.
Monty is appearing in those matters. RSCP requested to accept notice. Call this matter when it is.
Next week.
In September, first week of September.
No, next week.
Next week.
Next.
Was in fact in the month of August.
Oh,
Do you have any other matter?
Lordship, 38, 39, 44 and 45. 38, 39, 44 and 45.
38, 39, 44 and 45. Any earlier matter WP you have?
Lordship, it has been already kept to second week.
Second week. No, do you have number of that? Give number, at least we will call along with this matter. Call all
right now I don't have, I will give to.
Yeah.
Item 17, Passover item also RSCP.
17 also see.
10 mile. No, item 10 also. 10 also. 17 also.
10 and 17.
Item 54 mil.
1 second. 10, 17, 54.
1010.
110 also same.
No, 10, only 10.
Only 10.
Only 10.
Yes.
54.
Item 10 we have, what we have done?
That is also RSCP matters.
But 10 we adjourn the matter.
Yes. Next week your lordship is.
10 also take. 10 also. Yes.
Item 56.
All matters to be posted same day. We will post them week after next. So that next week matters also can be posted on that day, week after next. Yes.
Much. Very limited matter.
That's what we have kept it within 2 weeks. After issuing notice. You serve copies on the AGA.
No, that I have already solved. In one case, I have already solved.
Next.
Item 28.
May I please, Your
Yes,
Lordship? Well, the petitioner before Your Lordship is a hotel established. It is established as per the definition of a migrated industry under the 2016 Industrial Policy Resolution.
Industrial Policy Resolution. If that policy is drawn under which act?
It's under the Government of India and Industries Department draws it up.
Under which act?
This is not a statutory resolution. Executive instruction, and it is made applicable across the departments of the government. I'll just read out that portion of that resolution. If Your Lordship sees page 65 is the resolution.
You can tell it in gist.
Yes, Madam. The resolution provides that industries which fall within the various categories which have been nomenclatured under the policy, they would be entitled to certain benefits of the state, like
tax exemption,
electricity duty exemption, and so on and so forth. Now, this falls under the tourism industry, and the tourism industry also has certain benefits. Now, every department also frames a policy apart from the industrial policy resolution, but condition precedent is that it has to be in line with the industrial policy resolution of the state government. Now, the industrial policy resolution that the tourism department framed, that did not provide for a migrated industry. Migrated industry. Because my establishment, my capital investment happened at a time when the policy had not come in. I went into commercial production at a time when the industrial policy resolution had come in. And I fall into that category of migrated industry. I am entitled to the benefits.
It may be nascent industry or a existing industry.
There are three categories, in fact. One is a new industry. Second is a migrated industry. Third is an expansion in industry.
Okay.
So there are three categories. I fall into that migrated category. Now, tourism policy provided for a new industry, provided for expansion industry,
not migrated.
Provided for a migrated industry. And I got excluded in the process. So I made a representation there too. Not only me, the Hotel Association made a representation there too. And that writ petition is pending before this Honorable Court.
We'll call this matter along with that.
Yes, my lord. So that is what I.
In the meanwhile, we issue notice also.
Yes. They also need to file a reply in here because in my case specific, they have also rejected.
WPC number.
Learned DGA is requested to accept notice for all respondents.
All respondents.
All respondents. Call this matter along with WP number
37811 of 21.
378.
Number you can say.
37811 of 21.
In the second week of September. But if these are matters of policy,
yes, perhaps,
then it is bit arguable. But if there is a grand policy and subsidiary policy, if the grand policy requires that subsidiary policy should be consistent with the grand policy, then you have a case.
Yes, that is my case. That is my case. There is a specific provision in the IPR, in the Industrial Policy Resolution, that if there is anything inconsistent with this policy, it has to adhere to this. It has to fall in line with this.
They could not have excluded migration industries from that.
Absolutely.
Because the grand policy provides for that. Okay.
Item 30.
Yeah.
29 adjan.
29.
Petitioner is a retired primary school teacher.
What is that 29, brother? Is it a case?
That is a expression of interest to supply the school dresses to the institutions. In fact, it is coming under the tendering process also. So that they have invoked the jurisdiction of the Supreme Court.
He has taken time. Yes, brother.
I don't have here the petitioner is a primary school teacher retired.
Make use of the mic.
Petitioner is a retired primary school teacher. Prays for a direction to this for a grant of actual financial benefit from the date of 26/3/1993.
Retired teacher.
Yes, Lord.
When he retired?
31/8/13, Lord.
21/8/13.
Yes, Lord.
But where were you all these years?
Because the government on a faulty decision has not promoted this petitioner along with others to the post of headmaster, which has been in violation of their own guidelines.
So what is the explanation for the delay?
No, my lord. Thereafter, we have filed this petitioner along with others filed writ application that
earlier.
Yes, my lord.
When it was?
In 2021, and that has been allowed with a direction to the opposite parties to consider the same. If junior person has been promoted to the headmaster, then his case will be considered. And accordingly, Annexure 5.
Junior was promoted?
Yes, my lord.
Where is that?
One Gagan Das, whose serial number is
page number
24. And that has been decided.
No, we want to see now.
Yes, Lord. Page 24.
With serial number
111.
111.
Lord. He was promoted on 26/3/1993. But there,
where is that? That is not available. 4350 date of birth is there.
Yes.
11/7/54 date of birth. Then date of appointment is 1/11/75.
1/11/75.
You got appointed when?
Prior to him.
Show that. Where do you figure?
Yes. My serial is
Paramananda.
80.
80.
80 Vallabha.
Different.
And this is 82 kind of.
82.
Paramananda
Rao.
80 is somebody else.
Yes.
82.
Yes.
So your junior is promoted?
Yes, ma'am. They have given promotion on the basis of the BD qualification. Resolution.
You got BD when?
That is 81. In that column, it has been mentioned.
81?
Yes, ma'am.
Here, the Paramananda was given, not Paramananda. The other person was given promotion on which date?
On 26/3/1993.
26/3/93. He also got BED.
Yes.
But you got BED prior to that.
Yes, my lord. But a resolution has specifically stated that they have the
Take
notice. Mr. Mohanty.
Your lordship has
Annexure 8 at page 46, my lord. There is a representation of the person concerned. But I beg to submit, my lord, in this respect to one judgment of our own High Court P. Bengali Patra, this has been well decided. Whether there is an appeal or not, that I have to search for. But
that has
on
been
that
decided.
score also, they have filed this representation. If that can be
We see Annexure
I
7.
will come forward with a counter.
You come with a counter. How many times? We will give representation. You consider representation.
Extended by these coordinates of this court.
Has extended that benefit?
Yes, my lord.
That is Mr. One thing.
That I am exactly submitting, my lord. That is exactly I am submitting.
Annexure 7, my lord. Your lordship has already decided.
Why can't you look at the judge? Look at the judge. He wants to issue notice.
Your lordship, please.
Issue emergent notice. First one. Call this matter in the second week of September, since it lies in the narrow pass. And it is said that already similar matters have been decided on merits. Okay. Second week of September.
Yes, my lord.
At that time we can give it.
On 6th of this month, your lordship has disposed of similar matter.
Similar matter.
That is third.
On merits we have said.
No, my lord, because in review application.
No, I am asking you. Whether on merits we decided the matter.
No. To consider that representation.
That what consider representation.
No, my lord.
Rather it will come to an end. Rather it will come to an end.
Rejected. Again you will come here. I have seen the pattern how the government works here.
My lord.
Rather it will come to an end after filing of the counter.
They want to keep the all citizens in the court corridors.
My lord.
As a rehabilitation center.
Yes.
That's not the object. They should do something. Otherwise, I would have given that order for disposal. Very good. No use will be for.
Item 52 also said.
52 also. Call along.
Oh, bless.
Mr. Mohanty, we direct the consideration of the representation not for the purpose of rejecting it again and sending the client litigant back to the court. Consideration should be on some normative basis. And we should believe, yes, government has.
And there should be a reasoned order also, not that way.
Reasoned order. Reasoned order with sense of justice.
Yes, exactly.
Then nobody comes to court with joy.
Otherwise, repetition of the same charge.
Yes.
Item 31. May I please, Your Lordship? The petition is a president of a Journalist Association of Noida. Made an application.
Which association?
Journalist Association.
Journalist Association.
Made an application by the Annexure 2 for accommodation a room in the collectorate on basis of the representation. Annexure 3. By the Annexure 3, the collector held a meeting, and Annexure 4, they have already issued the order for accommodate the same to the petition association of the petition by the Annexure 4.
Annexure 4?
Yes, running page 15, Your Lordship.
What he has said?
May I read you?
Press room will function according to government office hour as per resolution number so and so. Has been functioning. The quarters user will continue till receipt of the guidelines from the. That room they have given to you.
No, press room has already been accommodated. But till now that has not been given.
So where is that press room?
Thereafter, I have already made an application to accommodate the same.
Yes, brother, you have already. There is some order. See, 3/5/2025.
And there is an annexure 4 at page 15.
You have already provided.
That is the official order.
That you implement this order. Petitioner, an association, being the secretary of President of Journalists Association, is knocking at the doors of the court, seeking essentially a direction for implementation of office order dated 3/5/2025, a copy whereof awails at Annexure 4. First off, learned counsel for the petitioner submits that the said order has been issued by the collector and district magistrate of Nayagar district, in terms of which a room is assured for being used by the journalists in accordance with the extent policy of the state.
From the I&PR department. I&PR department. Information and public relations.
After the inspection.
Information and
public relation, man.
No. under the supervision of the DIPRD, that is Department of Information and Public Relations.
Yes, ma'am.
Office. First of all, he tells that though more than 3 months have elapsed, nothing has been done in the matter, and therefore this court should intervene. First of all, Basantu. Next paragraph. Learned AGA Mr. Mohanty, on request accepting notice for the respondents, opposes the petition contending that the office order is not a statutory order and therefore it is not justiciable. It is more in the nature of a gesture of the government. First, having so contended, now he agrees to instruct his officers to look into the grievance of the petitioner in terms of the subject office order within a period of 2 weeks, 4 weeks, within an outer limit of 4 weeks, towards its implementation. First of all, this is a happy thing to happen in adjudicatory process. First of all, next part, with the above observations and assurance put on record, common petition is disposed of. No question. 32. Yes, sir.
Yeah, this case, my lord, the petitioner has been suffering and also retired in the meantime on 31/7/25 without getting a single pie towards the dues available to him by an order of the authority also. But the fact is, my lord, he was appointed as a clerk. He was
appointed on which date?
My lord, he was appointed in the year 1991, 15/3/91.
15/3/91 as
a clerk. Clerk cum typist of a aided college, man.
Retired on which date?
31/7/25, my lord. 8 days back. Lord, what happened, my lord?
31/7/25.
Here, July.
July 31.
My lord.
2 weeks, 1 weeks are over.
Yes. 31/7, this July last, my lord, we are in, as today is 8th. 8 days.
31/7, last day of July.
Yes.
1 week.
1 week is over.
1 week is over by that today.
But for settling the pension,
no, that is exactly the pension because it will flow from the order. Just I am allowed to pay. During his incumbency, my lord, illegality was committed to him. He has approached the director with regard to his service approval. And a person who is not entitled to a junior was given the benefit. So I had approached the director. Director, in fact, passed an order in 2014. 26/2/2014. That order was signed by the director saying that I should be given that post and on joining I will get all the benefits. That was the director's order. It is that there at my lord, I have annexed is Annex 3. But to my misfortune, my lord, that order was not issued from the directorate because the director concerned retired on 28/2/2014.
He signed and retired.
Signed in 26, 2 days after he retired. That was not issued. So I had wagged my head there. I came to this honorable court. And only after interference of my lord here, the order was communicated on 5/11/2024. After contempt, all these things, my lord. 5/11/24. Thereafter, I was allowed to join. Even after again another writ petition here, I joined on 25/11/24. As per the order of the director, my lord.
To that other post you joined.
Same post, my lord, the clerk post.
So which was the?
The post of clerk
already, na?
Yes, that is the clerk post. I have been allowed to join because I was not allowed to join in the relevant time.
On 15/3/2014, you were not allowed to join.
Not allowed to join because of the director's order could not be communicated since 2014 to 2024, 10 years, my lord. I could not be allowed to join because of non-implementation of that particular order.
Yes.
So, my lord,
however, it was allowed to join. The director's order was in my favor, wherein it is stated that the period you are out of employment, you will not get any service, but the notionally it will be fixed. The other period on joining, I will get it. But because of this peculiarity I have stated to my lord, that is why I haven't suffered. And in the meantime, I have retired on 31/7/2025. Hardly I have served for 7-8 months, my lord.
You want
my lord, because unless they get my service approved, because there is a formality. Even if director has passed, he is the order of approval authority. But unless there is a formal order of approval of my appointment, I am not getting my salary for that period. Whatever the entitlement I have. But and then consequence is the pension, my lord. This is how I am before my lord. If he has retired after serving for so many years, he is not getting anything.
How many years he served?
He has served, because actually, if you will go by the order, my lord, I was to be joined. I have 8 months. I have served, in fact. But as
8 months salary is given to him.
No, nothing is given.
Even that is not given.
Not given.
For a salary is concerned, you have to make that payment is one thing. But whether
the pension, I will automatically I will get it, man. Once the salary will be paid, as per the rules, my lord, I am entitled to pension because my service is to be
counted. Be paid salary, it will be diced on.
Yes, man.
When how will you get the pension?
Yes, that is yes. The qualifying service, as per the order, my lord, it is there from my 91. Qualifying service he has accepted, but it will be notional.
How I will not pay service?
Qualifying service from 15/3/1991, my appointment.
But you never worked at all.
No, that is why I will not be paid. No work, no pay. But for the purpose of other benefits, I am to get
pension also.
Pension, everything I will get, man. Because that will be notional.
Give one rule, one.
That is the order, my lord. Can you see?
Order is passed like that now.
No, that was the order, my lord.
Where is that order?
Kindly see, my lord, Annexure 2. Sorry, it is yes, Annexure 3. And let us go to that operative person salary, my lord.
Yes.
This will be Annexure 4.
No.
4,
Page 18.
Annexure 3, there is nothing.
No. Annexure 3, the continuity, na. Page 18.
Page 18.
Annexure 3, na. My lord, page 19 may conducive.
19 last part.
There is 3 names. See, Ajay Kumar Ponda was originally appointed as a junior clerk against this +3 stream. But strangely, as the appointment letter dated 11/8/1987 shows he was appointed as a senior clerk. Taking this kind of duality into consideration, Sri A.K. Ponda's seniority to the Vidyadhar Giri Lakshmidhar Pradhan is not accepted. Had Mr. A.K. Ponda really been appointed on 11/8/87, his name must have been reflected in the selection list. But ironically, the selection cum merit list, he doesn't occupy first position and the second one. So Sri A.K. Ponda may continue as a clerk of the college at the cost of the college. Since as reported by the college authority, he is serving them since 11/8/1987, the college may retain him at their own cost. However, his retention as a clerk in any wing shall not affect the intercession among the clerks in the said college as adjudicated above. Adjudicated above, my lord, just kindly see, my lord, these 3 names, Vidyadhar Giri, Lakshmidhar Pradhan, Santosh Dhala. I am Santosh Dhala. 3 posters admissible for the granting at the be published in the net with necessary correction in respect of publication already made in respect of clerk in the said college. See, Santosh Kumar Dhala is directed to report to the principal cum secretary and
is granted.
Is
last line.
Yes, madam.
Submitted letter. Continuity of service is granted.
So that is why.
That cannot be before 26/2/2014.
No, madam. Shall I read, madam?
It cannot.
However, just I am completing the sentence, madam. What it says. He submits the letter dated so and so. However,
Mr. Monti, accept notice. File your objections.
However, for the entire period of non-performance of the duty as a clerk, he shall not get salary. However, it shall get notional annual increment
and service continuity.
That service continuity, according to is 15/3/1991.
Otherwise, I would not have been there in that college.
And it will be college was admitted to grant when?
1994.
94. But you mean to say even 1991 service should be counted?
For the other purposes. Because all the employees of the added age, that was the rules, my lord. The pension rule also says.
Not very sure of.
No, that is the rule. I will show it. My lord, what it? I will show.
You accept notice. At least that salary, whichever money he has worked, that should be immediately paid to him.
That I will take instruction.
Why you have retained that money?
Salary
Other things whether he is entitled to or not, we will discuss afterwards. For the period he has worked, no person can be deprived of the salary under Article 23.
Yes.
The doctrine of beggar is enacted. Beggar is the only native word used in the Constitution. Beggar means asking a person to work without payment or underpayment. There are beautiful judgment. There is one judgment of Apex Court, State of Rajasthan versus High Court of State of Gujarat versus High Court of Rajasthan. Perhaps year 1999. So can anybody take out that judgment from Google?
One judgment I have collected, that is though it is of my lord Andhra Pradesh High
There is a
Court.
Supreme Court judgment.
Yes, that has been, all the Supreme Court judgment has been taken note of
in that.
right from Kerala.
That High Court of Karnataka.
High Court of Andhra Pradesh. So I found
they say
this has taken all this point. Yes, sir.
You cannot make more research than me.
No, definitely.
I don't know any other job.
I never claimed.
In that case, prisoners were not, they were made to work in the jail when they were serving the sentence. They went to court saying that we cannot be compelled to work during my service while serving the sentence. The Gujarat High Court said, you paid. Matter went to the Supreme Court. Very strange case it is. The State of Gujarat versus High Court of Gujarat, Honorable High Court of Gujarat. The Apex Court said, under Article 23, which enacts beggar, even the prisoner should be made payment. That judgment you should have updated. And pursuant to that, Karnataka High Court judge also, who is now Orissa High Court judge, has made rendered certain judgments. You can look into them.
That is the year 1998 Supreme Court.
Correct. 98 Supreme Court. Correct. Just look it up.
Yeah, 1998 Supreme Court.
3164.
Yeah. Law keeps on marching. Law keeps on marching from April to May and to the June of life. Yes, take this.
Lord, I have to take notice on that private governing body is there.
Issue emergent notice to private respondent.
OP number 3.
But the official respondents are directed to consider the payment of withheld salary for the months of actual service which the petitioner has put in and report compliance on the next date of hearing. That money you cannot retain. Immediately you have to make the payment. Why if a pension is not paid, salary is not paid? What kind of state government? I do not understand. If there is any ground, I don't understand. The persons who have retired long ago, they are just hovering in the court corridors for getting salary. Consider representation. Consider second representation. Consider third representation. That means whole of the life, they have to be here only. Yes.
33.
Next date you report to call this matter on 20th. For payment of salary, you have to report that. I will call this matter on 20th.
28th possibly holiday, but it went 29.
Why? 20th is not holiday. Unless you declare one.
20 तारीख कहीं हॉलिडे
20th.
Yes.
May I please, madam? This is a matter of prayer for regulation of service. I am working as a laboratory assistant in engineering college, namely Indira Institute of Technology.
How long you have been working?
Since 2009, my lord.
2009.
Annex 2 is my the appointment order. Running page 20, my lord.
What they say now? You can't be regularized.
They
are in guest faculty. That was the.
They are saying that I am the guest faculty, but I am working.
You are
there.
permanent guest.
No, my lord. according to there is only one post vacancy. I am only one working there. Though 4 posts are required, I'm only one working there. Both in regular and
You are still working?
my lord. And running page, my submission, paragraph 8, I'm clarifying that.
Any other person regular appointment is made now?
No.
No regular appointment is made.
Only one I'm working there.
And the order impugned of 2024, wherein an executive order, which is the impugned order under challenge, man. Therein it has been clarified that because of the guest faculty.
How many years?
That I will answer.
Issue emergent notice. Any interim order you sought for?
No. If two things, I am also regional provident fund commissioner to also make a party for my provident fund.
Well, here also, one is the government. 2 and 3 are the independent authorities. They can issue notice independent.
Notice to 2 and 3. 1, Mr. Mohanty, 2 and 3 emergent. Okay.
34. Your Honor, I am petitioner in person.
Yes, sir.
Petitioner in person. My prayer is only for restoration of my WhatsApp number by OP2.
WhatsApp number?
Yes.
What is phone number?
Page number 8, Annex 1.
Page number 8, Annex
1. On 26th May, they have deactivated my WhatsApp number for the first time. Yes. I complained at OP1, that is at page number 9, Annexer 3. When I filled up the form, I came to know that our country code plus 91 is not there. That is at page number 11 and 12. The screenshot I have given, page number 11 of Annexer 3 and page number 12. Our country code plus 91 is not there. Afghanistan's country code plus 93 is there, but our country code, India's country code is not there. I have taken the note of OP1 of that.
Notice. Yes.
Item 35.
May I please, my lord, similar matter posted to my lord, second week of September, my lord.
Third week.
Third week, my lord.
Emergent notice. Do you have number? WP number?
WP number, my lord.
He is requested to accept notice for the respondent. Call this matter along with WP.
21,721.
Of 25.
35.
21,000.
25, my lord.
25.
Yes, ma'am.
All right.
Oblige.
36.
May I please, your lordship?
Yes, sir.
My lord, this matter related to the non-issuance of this caste certificate in favor of the petitioner.
Non-issuance of caste certificate.
Caste certificate, your lordship. My lord,
which caste your client belongs to?
ST.
Scheduled tribe.
Kondo.
You have applied for that?
Yes, I applied. That was rejected. Annexer 1, your lordship.
My lord.
Rejected by whom?
By the opposite party number 4, Tahsildar.
Tahsildar. You have no appeal on that?
There is no appeal, my lord.
No appeal. There is appealable order to
appealable. My humble submission. Let
me place the
my humble submission before lord. So why I will come before your lordship. Kindly peruse Annexer 3, your lordship.
Annexer 3?
My lord.
What it says?
See, it starts from page number 18, your lordship. This is the caste certificate issued by the opposite party number 4 earlier to my father.
Correct.
Thereafter, my lord, all my relatives are also.
That's all right, but you have appealable remedy.
There is appealable remedy, my lord.
You go before the appeal. We'll direct the
without an inquiry, my lord, I am before your lordship. I will file the appeal. But without going through any inquiry,
No, that a ground can be a ground in the appeal itself. You take up that ground also.
My lord.
We'll permit you to file appeal within 2 weeks. Let them decide the appeal within 6 weeks. All right.
Because I have applied for the rehabilitation scheme, it's a short period may be given, my lord.
Therefore, 6 weeks. Because they have to undergo, because of that Madhuri Patil versus State of Maharashtra.
My lord, this is that 95 Supreme Court, my lord, Madhuri Patil, the SLBC, my lord. But here, so far, this rejection is concerned, though it is appealable, but backdrop of the case is, they have applied for the belongs to Kanda. Subsequently change the religion to Christianity. Then, my lord,
Christianity.
whether they come under that rejection category,
they will not be.
Exactly, that's they see. See Silvasa, that recent judgment of Hon'Ble Supreme Court, whether they will come under the fold of reservation or not, that is the question.
Once you are converted to other religion,
that kindly have a glance.
Where is that they have stated?
Nothing is there. Without inquiry, they rejected my application.
That's ground, my lord, that's core. But can I have a glance to page 19, 18 and 19?
89 is yes. That was issue.
It belongs to Kandha by tribe and religion is Christianity.
Christian.
But here, your lordship.
You belong to Christian. Now we will declare that you are a Hindu.
No. Prior to that, my forefathers already converted to Christianity.
Therefore, Christians are not entitled to benefit of reservation.
That is the latest.
Okay, my lord. I will file an appeal. Thereafter, then
Where is the question?
Where is the question now?
No, my lord.
The caste systems, though it
my
is
lord, my humble submission.
Please understand.
My lord.
When court is saying something, it says because we see hundreds of cases, which advantage generally lawyers will not be having. You may be more intelligent, but we are more experienced. Because every day, every hour, we make value addition.
My lord, I will.
All right. The Constituent Assembly debates, if you see, Dr. Ambedkar said, those who leave Hindu fold, they would not undergo any suffering. Because caste system, though it is a bad system, is prevalent amongst Hindus. Of course, in some other communities, like there are some strata in Muslims amongst Muslims, like Khojas, many other communities, sub-communities are there. But caste system as such operates only in Hinduism. Though it has no good character. But once you go out of the fold, you are not entitled to caste benefits at all. You are not in the caste at all because Christianity does not admit caste system.
Yes,
Allah, how to grant you?
There are one. Christian Muslims are.
They cannot.
But earlier, my father was told me.
Therefore, you are not entitled to. Merely because your father got it. Maybe law was not settled. Maybe that there was non-consideration. You are not entitled. Petitioner is grieving before the rejection, before this court against the rejection of his application for the grant of caste certificate. First, learned counsel for the petitioner argues that he belongs to a scheduled tribe.
Well, I am permitted to withdraw the application.
First, petitioner having argued the matter for some time in relation to rejection of the certificate for caste certificate of social status, seek leave of the court to withdraw the petition unconditionally. First, petition is disposed of as having been withdrawn. He has filed a memo to that effect also. If the case is dismissed as having been withdrawn with no liberty to re-agitate on the same cause of action. First off, a copy of this order shall be sent by speed post to the respondents for their file. Yes.
Item 37.
It's decided case, my lord. I'm just giving out the charge. This is with regard to grant of areas. Recently, my lord, have passed this order. Also, my lord, have passed an order in a writ appeal also.
Will issue notice now?
No, my lord, it can be this last week. My lord, we have decided one issue. It is same order. My lord's order is also. No change is required.
Same one. Just date. AG put mutatis. We have copy to be acted upon. In every order you write that. But yes.
Item 40.
This is no, which one now? This code of is 39. 37. 38, 9 or this
38, 39, that is similar matter. No?
Pardon, my lord. On behalf of Mr. Das, my lord, can I pass over, my lord, from the old, my lord?
What
requested me? I have no power and no file, my lord. Requested me to on the, my lord.
Also,
only pass over, my lord.
Do you have objection if I issue notice?
Your my lord, state is not a party that State Cooperative Milk Producers Federation. And did you umpire their panel of lawyers?
Issue emergent notice. Take this. Fine.
41.
My lord, I pray for a Passover.
Passover. What is this matter about? You said few words.
The petitioner is not getting the UGC scale after
Similar matter. This is a second round of litigation. Notice to be issued, madam.
Emergent notice. Heard. Shri. What's your name?
S.R. Behra, my lord.
Heard. That's true. Mr. S.R. Behra, who argued well. Full stop. Issue emergent notice. Learned AGA is requested to accept notice for respondent of OP number 1 and 2.
I'm for OP number.
All OPs.
All OPs, 1, 2, 3.
Not
Item 42.
Non-contribution is a representation against the order of transfer. My petitioner is a primary school teacher. While continuing his session in the school after 1.5 years.
Mr. AC.
My lord.
Consider similar matters. Yes. No, we have made that. Do you have copy of that order? Where is it? You are transferred from which place to which place?
Answer 4, my lord.
From primary school to
Chanchunia private school.
Petitioner is grieving before the writ court against non-consideration of his representation against the transfer order dated 24/7/2025 issued by the block education officer Paramba at Annexure for first time. Learned counsel for the petitioner drawing attention of the court to his representation dated.
Answer 8.
Date, tell the date.
26/5/2020.
26/5.
Obviously. My transfer 24/7/2005. Transfer.
And you gave the representation on
26/7. Yes, sir.
The counsel for the petitioner draws attention of the court to a copy of the representation dated 26/7/2025.
It is dated 26/5.
Must be 7. Must be 25. A copy whereof awails at Annexure 27, wherein he has pleaded some difficulty as to why the transfer order should be kept in abeyance. First of all, he argues that once such a representation is given, it is the duty of the respondents to consider the same on urgency basis basis, keeping in view the observations made by the apex court in Varadha Rao versus State of Karnataka. First, next paragraph. Learned ASC, on request appearing for the respondents, opposes the petition, contending that petitioner holds a job which is otherwise transferable normatively, and that there will be no difficulty in considering his representation in accordance with law if all contentions are kept. Personal. This is applicable. Next paragraph. In the above circumstances, petition is disposed of. Time for consideration and informing the result thereof to the petitioner is 8 weeks. First off, till consideration takes place, the subject transfer order, to the extent it relates to the petitioner, is kept in abeyance. Petitioner to continue, is permitted to continue in the same school wherein he has been serving all through. No course.
43. May I please, Lordship? In this case, Lord, I was appointed as the principal in charge of the college.
Make use of the mic. Our mics are not working, like judges are not working. Mics also are not working. How substandard mics you have put in the courts? They don't absorb at all. The voice is not absorbed. They have to hold it to the mouth. Yes.
So, I was appointed as the principal in charge of a college, Lord. While I was continuing as such, another person was deployed to in my place, and it was challenged by the petitioner, and this Hon'Ble Court granted the interim order. Thereafter, I was also again allowed to continue as the principal of the college. Now, in the meantime, 2 years last. So, the charges, but after I resumed the duty of principal in charge, the charges was not handed over by the opinion number 5. In that regard, I have approved the director. Higher education, that may be consumed. The grievance is pending before the director of higher education.
There is an order to posting you to that
Yes, that is there.
Other person is holding the charge.
He has already been retired from service.
He is retired from service.
But that relevant
Grievance is not giving the detailed charge.
Yes.
In charge arrangement.
Detailed charges, while he was continuing as the principal, all the charges, the day he left that post, he should have been given all the charges to me.
The charge.
Yes. All the charges had not been given to me.
Memo, transfer charge memo is not signed by him.
No.
But you are occupying the post.
Yes. Some charges has to.
Lordship, director has opinion number 3 pending before the director of opinion number 2.
3. Opinion number 3 is to be found. Annex 10, page 28.
Petitioner is grieving against non-consideration of his representation dated 15 January 2025, wherein she has raised some issues relating to transfer of complete charge of the office which she has been holding pursuant to order dated.
That is dated 4/4/2016.
4/4/2016. You are posted to that place with effect from 4/4/2014. Pursuant to order dated 4/4/2014. But you said 22/11/2014, na?
Initially, I was appointed from that date, but in my place, another.
That is the order of this Honorable Court. 4/4/2016 is this Honorable Court's order passed in WBC number 2324.
Which squashed the other person's order and his order. Next paragraph. Learned counsel draws attention of the court to the earlier round of litigation wherein he secured victory against a private party, with some directions being made in his favor personally. The counsel complains that the representation of the kind cannot be kept unconsidered eternally. Personally. Next paragraph. Learned ASC, on request appearing for the OPs, although initially resisted the petition, now agrees with the suggestion of this court that the representation of the petitioner should be considered by OP number 3 at the earliest, regard being had to implications of non-consideration. First off, this is appreciable. Next, in the above circumstances, petition is disposed of. Time for consideration is 4 weeks. 4 weeks. Delay in consideration shall be viewed seriously. No course. Item 43. This is 43 now. 44 or 43? Disposed of one. Yes.
Petitioner is a reader in political. Similar matter already issue notice, my lord.
You should notice already.
Arrest matters, my lord. No, arrest me. No. Gratuity matter. 46. It already
issue emergency notice. Learned ESC is requested to accept notice for the respondents. Solve this matter along with WP number 20845 of 2025.
47 and 50 also same.
7?
47, 50.
47, 50.
Also
same.
Item 48.
Yes.
May I please? In this case, my lord.
Yes.
What has happened, my lord? The father of the petitioner was allotted with a plot, my lord, under Kotak Development Authority, CD. That allotment letter is available to my lordship under Annex 1, page 9.
Any plot is available to the judges?
Yes, ma'am. The quota is there, ma'am.
For judges also?
Yes, yes.
That was 3 to 70.
Okay. Well, allotment order is dated?
Allotment order is dated 18/5/2005. Annex 1, page 9.
18/5/2005.
But thereafter, the father of the petitioner, my lord, swear an affidavit and it was published in the Odisha Gazette with regard to change of his name. That is available to my lordship at Annex 2.
Name was changed.
Name was changed.
Then what happened?
Then, my lord, in the year 2023, on dated 18/10/2023, the father of the petitioner died, my lord. Natural death, died. Prior to death, he has submitted one application before the authority that I have changed my name and it has been published in the Odisha Gazette. So kindly correct the records. And after his death, my lord, in the year 2025, under Annex 4, dated 7/5/2025, at page 14.
What they have done?
The CD authorities had wrote a letter that you get a competent, you get a order from a competent court so that we can change the name.
Why?
So Odisha Gazette, it has already been published.
You said it thrice now.
Yes, ma'am.
Whether it is published thrice?
No, once.
Wait, brother, what kind of order is this? For change of name also court?
State is not a party, but the CD panel of council says
to take notice, emergent notice. Who appears? You appear for
Mr. D. Mahapatra usually appears.
In addition to taking usual steps, petitioner is permitted to self-compare the petition along with documents on the panel council. Usually represents the respondents. OPs.
Lordship, fix a date.
It will come. An emergent notice.
Fullest.
Item 49.
My lord.
Yes, sir.
My lord, in this case, my lord, petitioner challenge the arbitrary and illegal action of the opposite party number 3 and 4, my lord. Which as per the advertisement, there is a notice that those eligibility qualification, my lord, those eligibility qualification, he can appear at the work and interview and selected the. But opposite one or 3 and 4 engage fresher, those who are eligibility not eligibility qualification, my lord.
They don't have eligibility.
No, yes, my lord.
You have.
Yes, I have. But because initially I am working in this place under the opposite number 4, but initially in this college I am working as a guest faculty.
Since how long?
More than, my lord, since 2021 to till 2025, my lord.
2021?
Yes.
Now another guest lecturer is brought?
Yes.
Or regular lecturer?
Regular.
Another guest lecturer?
Guest lecturer.
He is already taking classes now?
Classes, they are just a MCOM, but MCOM is not a subject in the advertisement. My lord,
you were interviewed and selected. Your selection?
Yes, my lord.
Any selection process, some interview, something like that happened?
Yes, happened.
When it happened?
My lord, happened, my lord. Annexure, my lord.
Your MBA, NET,
yes.
6 years of teaching experience, NPTEL,
yes, ma'am.
MARD. They don't want qualified people in the institution.
But
their qualification is what?
Eligibility, basically, eligibility qualification is, my lord, that page 19, my lord.
19?
19. Annexure 1, Annexure 1, my lord.
MPhil and PhD?
Yes.
But you also don't have PhD.
But I have a PhD. My qualification is, my lord, in my Annexure 2, my lord. Annexure 2. I have not PhD, but qualification is I am a teaching experience as well as in concerned subject, my lord.
But PhD is also must.
PhD, my lord, in this case, PhD is optional.
How?
My lord, not that the priority shall be given on the following academic qualification. Priority shall be given, my lord.
Priority.
Yes, you are right.
What is the actual eligibility condition?
Eligibility qualification is a good academic record with a 50%, 55% mark, and an equivalent grade, and master degree in the relevant subject from the requisite university, my lord.
They don't have master's degree also?
No, a relevant subject. But
in the subjects they don't have?
Master degree.
Master degree they have, but no, not in that subject.
In that subject, yes, my lord.
Which is your subject?
My subject is, my lord, MBA in marketing, my lord.
Marketing?
Yes, my lord.
And the lecturer post is what?
My lecturer is post is, my lord, guest faculty, MBA, MBA FM, BBA, my lord.
Issue.
My lord, in the same similar matter, already 2 lectures also deprived the selection procedure.
They are also here.
Yes, Hon'Ble Court also is not direction to the authority
to continue you.
No, direction to authority to consider his representation, which is annexed in the.
They will reject the representation.
My lord,
because those who have violated the rule, they want to justify that no useful purpose will be served. We'll issue notice.
Yes, my lord, but those illegally selected, they are already
continuing them.
No, transfer already. Already they are, after complaint, they are already transferred.
You are asked not to come with effect from which date?
My lord,
you are stopped from working from which date?
My lord, I am since advertisement to till date, my lord. Advertisement on.
Are you still working now? No.
No, my lord.
When last you went to the college?
Last, my lord, next 6th June, 18th 6 2025, before 18th 6 2025.
Before,
yes.
In June you went to college.
Yes, my lord.
July, August you have not.
No.
Then we will issue emergent notice. Or you want consideration of representation. That will not help you.
Yes, sir. My lord, one two take us already issue notice.
We'll issue notice, wait.
And two case already direction to the authority.
Consider representation.
Yes, ma'am. Two cases. Three persons come to the. Yes, ma'am.
Who are the authorities? Why, brother? He has got a glorious qualification.
Here is the authority.
Belonging to scheduled tribe, scheduled caste. Does he belong to scheduled tribe, scheduled caste?
Scheduled tribe and also handicapped personnel.
What is this, brother? He has got
authorities at the university, my lord.
Huh?
Authorities at the university, my lord.
University,
my lord.
Does all these things?
Yes, my lord. I am for the opposite department 1 and 2 director and the government. Two person, I was 3 and 4. Who is doing such type of illegality?
Who appears for the university? You bring university council. Bring university council. We will pass order.
And see, my lord, but I don't know this university panel advocate. I don't know, my lord. There is a Keunjhar Dhandhar University, my lord. District Keunjhar, yes, my lord.
You take emergent notice. That is returnable within 1 week.
Yes.
Cabinet DGA is requesting issue notice. Cabinet DGA is requested to accept notice for arrest. OP numbers?
3 and 4, my lord.
You are 3
and 4, 1 and 2.
1 and 2. Emergent notice, returnable 2, 3 and 4, returnable within 1 week. Post immediately after service. Since matter lies in a very narrow compass.
Oblige, my lord.
Item 51.
The petitioner is a child who was studying in, my lord, Jawahar Nawab Vidyalaya. There was certain disturbances among some students, and he was sent to home. Thereafter, my lord, a notice was issued to the parents that you come and take the transfer certificate, that he was given a compulsory TC. The parents appeared before the RDC and also the authorities that whatever has happened, they have mended.
What happened actually?
Well, there was some dispute between some students.
Dispute relating to football. What was the dispute?
There was a small tussle between some children. That is there, madam. I cannot dispute that. The parents requested that we have taken the child for 1 month. We have given a good consultation. Please do not remove him from the school. The authorities insisted, sent repeated reminders, and they have issued a transfer certificate, possible compulsory TC to the child.
The school is a government-run school.
But it's a Jawahar Nawab Vidyalaya.
So it's a government-run school.
Central government.
You appear for the school?
My lord, for OP 1 and 3. 3 is the principal, the 1 in the Government of India school.
Generally, you in school, even I used to make that galata. If I had been sent home, perhaps I would have been very happy is another thing. But can it happen? Children are bound to fight with each other. By that, fighting spirit is learned. Competitive skills are learned. Such minor things happen. Na? Even brothers fight. Why have you given TC? For that, you should have counseled the child. You should have taken special care of the child. Unless he has got some psychopathic problems, where like schizophrenia or bipolar mania, where they become very violent in one part, very mild in another part. Bipolar extremes. Why you are doing that? It may not be correct. Ask your clients why anything can be done. Now permit the student to undergo. Now he is restricted, but he has set back now.
Yes.
You permit the child to under what any problem, psychic problem?
No,
psychotic.
Absolutely
Sometimes it will be there.
Yes.
But it subsides at the age.
Yes. And it is not a case of split personality, as your lordship rightly said, that the extreme two portions. It's not. There was some fight. I do admit, my lord. I don't say that I don't stand as a shield to the child. There was some dispute. There was some fight among the students. Well, that we have taken care. As parents, we have taken care. We have tried to mend our child. And such a harsh thing will have an effect on the child because it's just a class 7 child.
That's true. Do you know about, I do not know, maybe it was Thomas Alva Edison. He was also like that and very dullard, very mischievous in the school, very dullard boy. And the school teachers, they said, they sent a letter to the mother. He is useless and cannot be tamed. Better you tute him at home. In our school, we will not admit such student. Mother took child with her, and the child asked, "What is that letter you have received from the school?" Mother said, "You are extraordinary, and therefore it is very difficult to teach you here. You need a very special training because of your extraordinary nature. You are a brilliant child." Then mother gave tuition at home. Thereafter, after the death of mother, Edison found this letter in an old trunk. He started crying. If mother has told what school had written in this letter to me, perhaps I would have proved what the letters had stated. But mother taught him that way. There were such cases actually. In Sabarmati school, there was a very mischievous student, and it was impossible to tame him. Teachers went and complained to Mahatma Gandhi, saying he's very mischievous fellow, and you always preach non-violence. It is impossible to tame him unless we give him 1 or 2 slaps. Then Mahatma said, "All right, you beat him, assuming the character of his mother. How mother will beat the child? That way you can beat." So merely because some children are, they will be little mischievous. But you have to control all of them. This is one aspect. At the same time, there is another angle to this. All we have 1 or 2 children. We send the children assuming that child will be safe there. If highly mischievous child takes a knife from the dissection box and does some mischief, what the children should do, what the parent should do. These aspects are also there. Just look into. We'll call this matter on Monday. Now child is not going to school. Since how long?
Well, he has been given transfer since month of April.
April? But why are you so late?
My lord, their parents were completely frustrated. My brother belongs to the same neighbor. He told them, "No, let us try, because if something can be done."
Call this matter on Tuesday.
My lord.
Yes. Call this matter, issue emergent notice. Who are the parties?
My lord, in fact, my senior is the contesting parties. One is state. State has already received notice. He is the person who has given the transfer.
Issue emergent notice. Why government of India? It is run by a
central government.
Why government? You should have made President of India a party. His rule and principle will be necessary party.
Technically here,
issue emergent notice. Mr. AGA on request, ASC on request accepts notice for response number 2. Notice to 1 is dispensed with. Learned CGC, Senior Panel Counsel, appear for respondent number 3 principal. First off, since educational career of a child is involved, matter needs to be treated on urgency basis. and therefore post it on 12/8. 12.
Madam, they have given a reference to the RDC revenue, but they have not made a party.
That will not help.
Three.
You do something. You take that child back. You take that child back. Let child be sent for counseling. You don't have counseling agents for a group of schools to advise the children, or child psychiatrists, like that.
No, it is not there because not there. My son was reading in DAV public schools up to class 12. There is no such. One thing I'll say with your lordship's kind view, as your lordship rightly stated, the mother and edition's mother, your lordship said that she did not provide that letter to the child, rather said that you are extraordinary.
Extraordinary. She was a great mother.
That is why it is very well said, my lord. The hand that rocks the cradle rules the world.
That's how it is.
Grateful.
Item 53, may I please, your lordship? I may be allowed to appear online, your lordship. Your lordship, the petitioner is a demonstrator, your lordship. I'm challenging the non-consideration of the representation right Annexure 5, your lordship. The petitioner, in pursuance to the order of this honorable court, has received the revised UGC scale, your lordship. However, while granting the
A similar matter posted to next week, madam.
Next week.
Covered under Ashok Mahapatra's case.
Your
lordship, but in this case, there are some other prayers as well, your lordship, because the RACP
will issue notice.
Your lordship may issue notice, your lordship.
Issue heard, Srimati, Miss
J. Jena, your lordship, Jacqueline Jena.
Who argued well and made out a case for issuance of notice. First off, issue notice. Learned AG is requested to accept notice for
only AC,
AC is requested to accept notice for all respondents.
Yes, ma'am.
All respondents. All this matter when they are posted. Any
last week it is a mistake. Not my lord, not all respondent. 1 to 3 I am appearing. 4 is the principal of the notices to go to.
Emergent notice to 4.
4, my lord.
Post immediately.
The autonomous college, my lord.
Post immediately after service. Okay.
I can be by
Obliged, your lordship.
Lord, sorry.
Yes, sir.
Yes. In 2016, I am suffering from the chronic kidney disease, my lord. For which, my lord, one of the kidney of mine was transplanted in the year 2016. Thereafter, I am continually getting treatment from my doctor, my lord. Now, what happened, my lord? Again, my kidney has been reactive. So the doctor advised me for transplantation of my kidney. Accordingly, my lord, the doctor advised me to arrange a kidney of related blood related. It is not possible on my part, for which, my lord, he again advised for arrangement of unrelated person by who is ready to yes, my lord, and for which, my lord, certain tests are required, my lord. And I made an application before the competent authority of number 2, my lords, and he, as per my application, requested the, my lords, of number 3 to conduct certain tests. But till yet, my lord, the option number 3 is not doing so.
No, they will do it after kidney completely fails. What kind of government? The kidney patient is here. Huh? Who is the OP number 3?
Number 3 is the, my lord, HOD of...
You inject the same virus to his kidney. He will know.
His representation is pending.
No, it is useless. I know what kind of concentration representations will meet at the hands of the authorities. The government does not generate confidence in the citizens. The first problem which Harold Liskey, the great professor in Manchester University, used to say, the modern political disease is that the government is first enemy of the citizens. It is true now. But in our Vedas, Vedic literature, we always used to say, Rajaha Pratyaksha Devata. He was equivalent to God because he used to look after the subject that way. We had no issues at all. With modern government, all these things are happening. Because kidney patient may vote or may not vote. Why we should treat him? This is the kind of attitude. We'll call this matter on Monday. You keep that officer present before the court.
Monday, it is not Tuesday.
Tuesday?
Tuesday.
But however, in the meanwhile, if consideration of the favorable consideration of the representation happens, he need not come.
I have not made any representation.
You have not made representation?
No, yes.
This petition has the representation. You can't ask a kidney patient to make representation, then from this table to that table to another table. In that, kidney will fail. Issue emergent notice. First off, since a person suffering from kidney ailment is complaining before the writ court and the matter requires consideration on a war footing regarding head to the enormity of the disease, call this matter on 12/8/25. Learned AGA to be ready with all instructions for arguing the matter on merits on that day.
May I play one thing?
Yes.
Yeah, in every week, one day they are doing test mail. So for this type of tests are concerned mail. That is a 1 day mail. And if your lords will observe that there is no, if they will conduct the test on Monday, then
in the meanwhile, the jurisdictional respondents are directed to undertake the test and come out with a report on Tuesday. Okay.
Item 57.
We post that immediately. You inform telephonically. The learned ASC is directed to convey the gist of the order to the jurisdictional respondent within 1 hour. Yes.
Let's straight come to page 18.
1/8.
1/8, Lordship. The petitioner's disability certificate.
Which certificate?
Disability certificate, Lordship. Disability, Lordship.
He is a person of physical disability.
Lordship, with 100%, Lordship, kindly see.
Now what happened?
Lordship, now, Lordship, kindly the people of the state government, Lordship, Annex 2 is the guideline for transfer. And the transfer policy speaks of, Lordship, page 20. If a person continues for 5 years, then, Lordship, we may opt for transfer.
Well, retention period is 5 years.
5 years, Lordship.
Which is that policy?
Page 20, Lordship, kindly see page 20. Lordship, kindly see clause 4, the type of transfer 4.2. Just bottom of the page, Lordship. Page 20.
Transfer.
Let's say that's Odisha Adarsha Vidyalaya Sangathan Bhubaneswar transfer guidelines for principals, teachers, librarians of the Odisha Adarsha Vidyalayas, Lordship. And Lordship, can you come to 4?
How many years he has put in service now?
Lordship, that is 3 plus 3, around 4.
Less than 5.
Lordship.
Transfer to which place?
Lordship, he is now to Khorda, Lordship, from Cuttack to Khorda.
How many kilometers?
Lordship, it more than, Lordship, 50 kilometers, Lordship. 50 kilometers, Lordship. 50, Lordship. But he's unable to see, Lordship, that look at disability, Lordship, which is a blind, Lordship. And Lordship, kindly come to Annex 3 order of transfer. In fact, Lordship, that's 100 kilometers. That is 100 kilometers, not 50, Lordship. My friend is saying that is 100 kilometers, Lordship.
I thought that your friend was whispering that this judge is not favorable to transfer.
That's it. We are expecting more from this Hon'Ble Court, Lordship. And Lordship, can you please see place 42. How this function, Lordship, officials are working.
Any representation you have given?
No. Annex 5, the minister has himself said, Lordship, please cancel this order. Lordship, this minister has said, Lordship, kindly see the page 42.
But in other matters, you said the MLA should
that is Lordship, interference of the MLA and MPs. Here, Lordship, the government, state government is saying, please cancel or transfer, Lordship. 42, Lordship, last paragraph. In view of the above necessary.
Why, brother? He's a man with disability. Why do you want to more disability to him by your action?
Take instruction.
Issue emergent notice. Learned ASC is requested to accept notice for the respondents. The impugned transfer order, so far as the petitioner is concerned, shall not be given effect to till next date of hearing. And petitioner shall be continued in the very same school wherein he has been serving. First one, below that. This order, this reprieve has been granted, keeping in view the arguable 100% disability, visual disability of the petitioner, and the transfer guidelines which prescribe a retention period of 5 years, and also the Honorable Minister's recommendation letter. Okay.
That's only for copy, Lordship, in course of day.
Immediately we will get that.
Let's get for Lordship.
We are posting all copies.
Lordship.
Yes.
Like that. Grateful, Lordship.
Yes.
Please, my lord.
Yes, sister.
My lord, the petitioner was appointed as an assistant teacher in the year 1999, my lord. He has completed B.Ed course, my lord, since 2009, my lord. And he is continuing on deputation, continuing against a TGT post since 2014, my lord. But till date, he has not been considered for promotion, my lord. My lord,
any juniors have been promoted?
No, one post is also vacant. He is a SC candidate, and one post is vacant, but DPC has not convened, my lord.
DPC has not met?
No, my lord. In the Annexure 6, he has given a representation, my lord.
Annexure 6?
Yes, my lord. Base 17, my lord.
You are the senior most member?
Yes, my lord.
Consider petitioner's representation dated 23/4/2025 at Annexure A6 seeks her candidature for consideration for promotion to the next higher post, comma, he being at the top of the gradation list, in addition to belonging to OBC. First time. Kindly be seated. Sit down. Sit down. Learned counsel for the petitioner complains to the writ court that this representation is not being considered and that there is no hope of its consideration in the near future, unless this court intervenes. First time. Learned ASC appearing for the answering respondents, having initially opposed the petition, contending that the promotion is not a matter of right, comma, now agrees to instruct his clients, official clients, to look into the grievance of the petitioner as has been aired in the subject representation. First time. This is fair and reasonable. Next paragraph. In the above circumstances, petition is disposed of. First time. Time for consideration is 8 weeks, which would include conveying the result of such consideration. First time. All contentions are no parts. Other copy. Open to solicit information document. Next.
59.
Yes.
59 Lordship, that on the recommendation of the ML and NPC Lordship,
Same matter.
Same matter. 20875 Lordship, the leading matter of the
issue. Emergent notice. First time. Learned counsel for the petitioner submits that in identical matter, this court has already granted reprieve to other teachers and therefore similar benefit should be extended to his client as on the principle of parity. First time. there is prima facie force in this submission. First up, next paragraph. In the above circumstances, interim order as has been made in WP number
20875 of 2025, Lord.
20875 of 2025 till next date of hearing. First up, call this matter along with that case, that WP. Yes, next.
Let's to continue that person.
Same order.
Let's.
Item 50. May I please, my lord?
Yes, sir.
Challenging the order of rejection, my lord, Annex 11 for being appointed as junior teacher, my lord. In similar cases, your lordship has issued notice.
You have issued notice already?
Yes, my lord.
Issue emergent notice.
This is the interim order your lordship has
Interim order is also there.
Yes.
Emergent notice and grant interim order as has been granted in WP number 21014 of 2025. Case to accept notice for the answering respondents. Any private party?
No, madam.
Call along with.
Okay. Collected matter also same.
Same?
Yes.
Call along with. Same order, call along with. Yes.
Item 61.
61. None appears for the petitioner. Call after 4 weeks to enable counsel for the petitioner to comment on. Next.
Same
order. Yes.
63.
May I please,
yes, sir.
Lords, Annexure 19, Lords, is the impugned order 31/7/2055. Annexure 19, page 224. Here, fact is, Lord, the petitioner is the senior most reader, Lord, working in KB College, Lord. And he has been now deprived of this posting of principal, Lord. Annexure 19, Lord.
He is posted there.
Lord says, my serial is 91. A person who is serial is 771, he has been posted. I will kindly grade, I will show 2 documents to your Lordship. Lordship, kindly see the gradation list, Lords. Gradation list, Annexure 12, page 67, Lords. Final gradation list.
It is on in-charge basis.
Yes.
But on in-charge basis,
but Lordship, kindly see, I will go to the notification is also here. Lordship, kindly see page 67, Lords.
67?
Yes. That is the final gradation list, Lords.
No, I don't doubt your version at all. I don't doubt your version. I believe that.
And there is also, Lords, what I say, Lord, there is also a notification, Lords, page 190, Lords. 190. Lords.
What it says?
This is guideline for posting of principals in non-government aided colleges under higher education department.
On in-charge basis?
Yes.
Is it a case of in-charge or in the independent charge?
My lord, they say in that Annexure 19, they say it's a in-charge, my lords. They say in-charge. But here, your lordship, that is relevant is 191 page, lords.
Senior most lecturer?
Yes, lords. Procedure. And I will...
When that order was made?
Order was 31/7, lords, Annexure 19.
And take emergent notice.
No, I have given a representation, lords. Earlier, I have approached, lords, only... I have approached on 15/7. That is also through mail. And also 2/8, lords, I have also approached. Your lordship, kindly say I will represent afresh along with your lordship's order, lords.
You want to make a representation?
Yes, fresh representation.
You have not made any representation?
No, on 2/8, yes. Annexure 20 is there, my lord, but it was...
You have made?
Yes, I have made Annexure 20.
That is before filing the petition?
No, yes.
Saying what? You should be posted there?
No, I am praying for consideration of a case since I am senior most, my lord, in the gradation list.
What do you say, brother?
Let his representation be considered.
But consideration is not for consideration's sake. There should be some effective consideration in the light of your guidelines. Otherwise, the rejection, again, he will come here. Instead of doing that job, he has to be here in the court hall, court corridors. Within 2 weeks, you have to consider that. Simple. Nothing, no launching of satellite. whether he is senior or not, why his seniority should be ignored. That's the only case.
Relevant chart is also as page 187, Millers.
Petitioner claiming to be at the higher position in the gradation list is grieving non-consideration of his candidature for the post of principal, eventual vacancy having arisen on the superannuation of the then incumbent. First up, learned counsel for the petitioner, drawing attention to the normative position, submits that for the purpose of placing in charge or independent charge of a higher post, seniority is one of the criteria. And now the junior person having been positioned, the official respondents have grossly erred in law. First up. He also grieves against non-consideration of his representation for setting the same at right. Wide annexure?
Annexure 20, 17 and 20.
Representation.
Yes, on 17 I had given. On here, before that date?
Dated 2/8/2025.
And 15/7/25 also.
Annexure 9. Preceded by one dated
15/7/2025. Annexure 17. Through
that
mail.
was before superannuation.
Before superannuation I have given, Millers. That is through mail, Millers.
Next one. Learned ASC appearing for the respondent opposes the petition, contending that courts have taken the view wide Basavaraj N. Hutra versus Karnataka Land Army Corporation, ILR, so and so, that in making in charge or independent charge arrangement, ordinarily seniority fails into insignificance, now graciously agrees to instruct his official clients to look into the grievance of the petitioner, as has been aired in the subject representations, in terms of which rule it is? 100 order you said, na?
Yes.
Which is that?
Page 11, let's see, 190 page.
Page 190. Go to
Let's notification of 44890 dated 8/11/2024. 190 page, let's.
No, you said rules, na?
Yes. 190 page relevant 191.
Government policy notification dated 8/11/2024, a copy whereof avails at annexure, what you call it as?
This annexure, Millers. This is annexure 16 series, Millers.
Annexure 16, a part of annexure 16 series. First one. In that connection, he says, all contentions to be kept open. Next paragraph. In the above circumstances and with the above observations, petition is disposed of. First off, time for compliance is 2 weeks, reckon from this day. First off, delay shall be viewed seriously at the next level of legal battle if petitioner is driven to. First off. Now no cause. Web copy to be acted upon.
Petitioner will file a fresh representation along with.
No, not necessary. Why fresh? You have already given 2 representations.
Grateful.
Why, brother? Why representations of the employees are not considered? All they are driven to the writ court. This is become not writ jurisdiction, representation jurisdiction.
Unless they come to their knowledge, my lord. How can it?
You should warn them. In appropriate case, I will impose heavy cost to be recovered from the concerned officers. If they have given a representation, even if for pulling down a particular building, you should take a decision on that and inform them we cannot pull down your building unless your own building is pulled down. But you do not answer them. Stony silence, like a rock of Gibraltar. Yes, that full.
Section 64, may I please, Your Lordship?
Yes.
Group D, casual labor of Orissa University of Agriculture Technology. When her service was not regularized, then he approached this honorable court.
How many years of service you have?
My lord, more than 30 years of service.
30 years?
My lord.
Issue emergency.
No, Your Lordship.
Why I want to issue notice still?
No, Your Lordship. But now she will be given a retirement next month for emergent notice for that reason, Your Lordship.
Therefore, I am telling you emergent notice. Emergent notice. First off, post immediately after service. AGA appears.
That is Orissa University of Agriculture Technology.
Any panel counsel of that?
My lord, for that, Your Lordship, my home submission, I will short copy to Abhijit from Mr. Abhijit Pal.
Copy of petition along with all the documents on the panel counsel who usually represents the answering respondent university. All right.
Your Lordship may indicate his name so that
post immediately after service. Okay.
Item 65.
Yes.
Well, this is a case of frequent transfer. Your Lordship may kindly turn to Annexure 3 at page 15.
How many years of service you have put in?
My lord, C was transferred for the first time on 2/8/2022. The normal tenure is 6 years.
My question remains unanswered.
Yes.
How many years of service he or she, we do not know, you are also not writing Srimati, Shri, etc. I have been telling every member of the bar, the Supreme Court has said,
yes,
every lady should be addressed as Srimati or Mrs. Miss. Every man should be addressed as Mr.
Yes.
Shriman.
Yes.
But nobody bothers about the Supreme Court nowadays.
Yes.
Yeah.
She is an unmarried lady. Letter of Shrimati Patel. My lord, first, Your Lordship may kindly turn to...
Why the registry is posting these matters without the prefixes? Why they are called registrar? Called registrar.
Well,
no, they should say Srimati, Shri.
Yes.
Something you have should say. Many rights arise because of gender.
Yes, is absolutely correct. But that is my mistake.
Yes.
Well, the first transfer was made.
No, but my question remains unanswered. Again, I am putting you
on.
How long she has been in service?
My lord, she has been continuing in service since 13/7/2001.
13/7.
Initially as Sikhya Sahayak, and thereafter her services were regularized as regular teacher.
In these 24 years, how many times she has been transferred?
My lord, so far as Sikhya Sahayak and junior teachers are concerned, that is not a transferable post. Those posts are not transferable.
Not transferred at all.
No, my lord. When she became a regular teacher, for the first time she was transferred on 2/8/2022. That is under Annexure 3.
22. Now transfer.
Normal tenure is 6 years.
Retention period is 6 years.
6 years. Then she was transferred on 24 July 2025. That is under Annexure 4 to a particular school. That is Government Upper Primary School, Daldali.
Did she report for duty?
My lord, just after one day, Your Lordship may kindly turn to Annexure 5.
No, I am asking.
Yes.
Did she report for duty?
My lord, she reported for duty.
24/7/25.
She reported for duty, but that was not accepted. Thereafter, just after one day, that is on 25th July 2025 under Annexure 5 at page 17, she was transferred to another school. On 24th, this order was passed under Annexure 4. And on 25th, that order was cancelled and she was posted to Government Primary School, Sagarpali.
How many kilometers?
My lord, kilometers is 50. 50 kilometers. My lord, so far as their guidelines is concerned, she is not a surplus teacher. Other station senior teachers are there.
How many teachers are there in that school?
My lord, number of teachers are there. Your Lordship may kindly see the guidelines at page 24.
No, actually working strength I want to know.
Working strength I have not given.
Your Lordship may kindly turn to page 24, the guidelines. For a moment, Your Lordship may kindly see the guidelines. My specific point is, she is not a surplus teacher. Your Lordship may kindly see that is 3.2 Roman 5. While transferring the surplus teacher from the school, the station seniority would be the basis of effecting transfer of a teacher, and who has maximum stay at a school would be transferred. Well, so far as this school,
senior most should be transferred.
Senior most should be transferred. Your Lordship is absolutely correct.
What is her ranking?
My Lord, her ranking, my Lord, in that school, my Lord, so far as the previous school is concerned, she has served for 2.5 years. Then the transfer order was cancelled.
No, but my question you are avoiding.
No, my Lord, I am not avoiding.
I asked you, again I am asking you.
Yes.
Please answer that.
Yes.
What is her ranking in the school?
My Lord, here, my Lord, I have brought to that school, that my previous school, on 24th July 2025. Because in other school, I have been serving since 2022. And I have ended
to ask you when she came to that school.
My Lord, Your Lordship may kindly see Annexure 3. Annexure 3 at page 15. The first transfer order, Your Lordship may kindly see.
No, I am asking you.
Yes.
Please answer. What is her ranking in the seniority?
Admittedly, she is not the senior most.
She is not the
senior most. I have categorically avowed in my writ petition, she is not the senior most teacher of that institution.
Because,
and another ground is, my Lord, she is 60% physically handicapped, visually impaired. I have given that certificate under Annexure 7.
Issue. Emergent notice. You give a representation. Till consideration of representation, you will not be disturbed.
Yes.
After that, if you have any cause of action,
well, I have already made a representation under Annexure 8.
Annexure 8?
Yes, to the director.
Right now. Petitioner who claims to be 60% visually impaired teacher is grieving against non-consideration of a representation dated.
That is dated 28/7/2025.
At Annexure 8. Annexure 8. Wherein she has sought for her retention in the very same school which is joined pursuant to the earlier transfer order dated 2/8/2022, setting aside the subsequent transfer order dated 25/7/2025,
yes,
whereby she has been posted to a place around 50 kilometers away. First stop. Next paragraph. Learned ASC appearing for the answering respondents on request.
Well, Your Lordship may kindly, I have submitted my joining report in that school, but my joining report has not been accepted.
In that school?
Yes. Your Lordship may make it clear.
25/7?
Yes. No, 24/7/2020.
You said that. I am referring to 25/7. I did not refer to 24/7 because
yes.
It is not a transfer order.
Yes.
Unless acted upon.
Lord has said that I have joined in that school.
My Lord, she has already been relieved, my Lord.
No.
Relieved?
No,
what happens after if you are relieved? She is not governor of a state, a teacher. With one pencil, one chalk piece, and blackboard. Yeah. First. Learned ASC appearing for the respondent opposes the petition, contending that every employee of the state is liable to be transferred wherever transferred, subject to all just exceptions, and the case of the petitioner does not fit into any such exceptions. First off, having so contended, he adds that already petitioner has been relieved from the post in question in the previous school, and therefore no interim relief or the final relief, substantive relief can be granted. First off, having submitted all that, now he agrees with the suggestion of this court to instruct his clients to look into the grievance of the petitioner as has been aired in the subject representation at Annexure 8, if all contentions are kept open. This is appreciable. Next, in the above circumstances, petition is disposed of. The representation to be considered and the result of such consideration to be conveyed to the petitioner at the earliest. First off, till that happens, petitioner shall be continued in the earlier school, namely
that is government upper primary school Daldali.
Upper primary
school Daldali.
Agree. Science. No. Of course. It is open to solicit any information, etc. Okay.
Item 66. Yes. Well, this is also a case of transfer. Here, my lord, your lordship may kindly turn to Annexure 3 at page 19. Just after 7 months, she has been transferred to another school.
Any complaint or?
There is no complaint. Your lordship may kindly see the guidelines under Annexure 4. As per the guidelines, the normal tenure is 5 years. This is a SC and ST Development Department school. Annexure 4 I have annexed. And my second ground is...
Representation given.
My lord, here my lord, representation will not do because I have not completed the normal tenure period of 5
that
years.
Itself is a ground for representation.
Then the second ground is, your lordship may kindly come to clause 2.4 of that guidelines. My lord, that is the very important ground.
Page number?
2.4, page 20.
20.
20.
While transfer and
posting of headmaster, I am a headmaster of class 3 and class 2. Female employees shall be posted to girls' high schools and girls' higher secondary schools as the case may be. Transfer and posting of a male headmaster to a girls' high school or girls' higher secondary school may be considered only when all the female headmasters are accommodated in girls' high school, girls' higher secondary school, and no female headmaster is left in the said cadre. Now, your lordship may, for a moment, your lordship may kindly see the transfer order.
This is violated.
Under Annexure 3.
It is
violated. I was in a girls' high school. I have been transferred to a
boys'
school. And a male teacher has been brought to my place.
And that too premature.
Yes. Premature. I have only completed 7 years. I have given that.
7 years?
7 months. 7 months. Only 7 months. Annexure 2. I came to that school on 2/1/2025.
Yeah, but you give a representation.
Well, representation will reject.
Urgent notice. Stay of LNDG accept notice on request for the respondent. Stay of transfer order. Coupled with the direction to continue the petitioner in the previous school.
That is Girls High School, Pena Goberi.
Girls High School,
Pena Goberi.
Pena Goberi.
In the district of Kannama.
In the district of so so till next day of hearing, call this matter on 13th.
May I please, my lord? My lord, the petitioner was appointed as the principal and come secretary of a degree college.
Brother, I have one small suppose I am staying so many transfers of teachers. By that, if students are put to prejudice, what should happen? I transfer this, the other person is relieved. And I continue to direct the petitioner to here only. He leaves that station, that school, and comes to this school. There will be nobody to teach those children. What should happen? Yes. Children will be put to injustice. Therefore, we will, wherever...
Unless relieved, unless that fellow who is in other school is relieved, he cannot join them.
He cannot join them. That's another problem. So it will have cascading effect. So something has to be done for that. You have to come out with some suggestion after having discussion with your clients. Otherwise, children will be put to prejudice. Because you have a transfer policy. You have a transfer policy. Ordinarily, transfer, this is a statutory transfer policy.
No, this is not a statutory, but
But anyway, there is a policy.
there is a policy.
But you do something. Either you change the policy, saying that every teacher is liable to be transferred, like any soldier under the defense, wherever, whenever.
They are violating their own
Whatever.
policy.
Huh?
They are violating their
That's
own
what.
policy.
That's what. You have to do something in that. Because in almost all teachers' matters have been staying. Because some
Most of
MLA
the-
said, some minister said.
Most of the cases, where no posting is, nobody is coming to their place. But only 2-3 cases, vice versa transfer is there. Otherwise,
Just look into that also. Next day, because I am posting this matter on 13. On that day, you please request your advocate general to come here. Do you have additional advocates general here?
No.
No additionals. Then tell that
Government advocate.
requested
Government advocate is there.
only government advocate. Yes, sir.
Okay. My lord, the petitioner was appointed as the principal cum secretary of a degree college, your lordship. Now he has been demoted to the rank of reader without any proceeding, your lordship. My lord, the conspectus of the case is, I was appointed as principal cum secretary vide annexure 1 series in 2023, your lordship.
2023.
My lord. 15/5/2023.
15/5/23.
My lord. My initial appointment was issued on 25/4/2023, which was modified. That was on 15/5/2023. My lord.
You were appointed as?
Principal cum secretary. Your lordship, may kindly have a look at page number 11, because that nomenclature is very important in this.
Is it a post or just position?
It is a substantive post, as principal cum secretary, your lordship. Page number 11, my kindly. May I please, my lord?
Yes.
My lord. My lord, in inviting reference to the subject cited above, I am directed to say that after careful consideration, the government and Department of Higher Education have been pleased to appoint Sri Nikunja Bihari Mahapatra, that is myself, reader in English, as principal cum secretary of Sadhu Gaurasar Degree College. My lord, this was modified to make it Sadhu Gaurasar College because Sadhu Gaurasar College has 2 wings. One is +2 wing, another is +3 wing. That is degree. Therefore, to cover both the institutions, he was made principal of both the institutions.
155.
My lord, challenging my appointment, opposite party number 4 had preferred a writ petition in this court, your lordship. And there was a direction to the government to consider his representation. And the government considered his representation and came out with an order. That is at page number 13 and 14. May kindly listen.
39 and 40.
13 and 14. 1-3 and 1-4. My lord, 1-3. Second last paragraph. Sri Ujjala Kanta Das, who is opposite party number 4, reader in mathematics, belongs to junior lecturer cadre. And Sri Nikunja Bihari Mahapatra, that is myself, reader in English, belongs to lecturer cadre of degree colleges. And Sri Nikunja Bihari Mahapatra is senior most in Sadhu Gaurasar Degree College. This is the factual position the government has taken. And my lord, the next page, that is at page number 14.
You are not senior.
I am senior. I am Nikunja Bihari Mahapatra. I am senior. I am degree college. I am a lecturer of the degree college. Opposite party number 4 is a junior lecturer of the junior colleges. Now, the government took the position that since the opposite party number 4 is appointed to a junior college and is a junior college cadre lecturer, my lord, at page number 14, they clearly say that such persons cannot be appointed as principal of degree colleges. This is the position the government has taken at page number 14. My lord, challenging this, the opposite party number 4
approached the court and court said consider.
No. That case was pending. During the pendency of that case, the opposite party number 4 transferred me to a different college. That is why annexure 4, my lord.
As what?
As principal.
As principal.
As principal.
Yeah, you are given post of principal.
My lord. But since my service is barely 5-6 months left, I approached this honorable court and this honorable court quashed the transfer order. Yeah, this Honorable Court quashed the transfer order by Annexure 7, Your Lordship. Now, when this transfer order is quashed, and I'm again joining there, the opposite parties are saying that no, Ujjwala Kandas, that person, he will officiate as the principal, you have to serve as a reader under him. That is the case, Your Lordship. And my Lord, this case has been decided by the division bench of this Honorable Court. The judgment I have annexed. Very interestingly, my Lord, in taking the position in that case, the Honorable Division Bench had taken our cases as comparative and said that a person appointed into a junior cadre cannot be posted as a principal of the degree college. The decision of this Honorable Court I have annexed, Your Lordship.
I have instructions to appear for opposite party number 4, man. But one thing is that in this case, my Lord, in the meantime, after the petitioner was earlier appointed as principal in 2023, I approached this Honorable Court. And during pendency of the writ petition, in this year on 2/6/2025, the government has come with a final gradation list, my Lord. In that gradation list, I am the senior most lecturer of this college, my Lord.
You are the senior most.
My serial number is 76 and the petitioner serial number is 190, my Lord.
Is it true?
Yes, my Lord. And he has nowhere challenged that final gradation list.
My Lord. My Lord, may kindly come to what my learned brother is saying. He is saying partially correct. That there was a gradation list published in this year, which is referring to. And he is saying that I didn't challenge it. My Lord, may kindly peruse the transfer order, which he is claiming the post. That order itself says that the particular gradation list he is relying upon is under challenge and every appointment is made subject to the result of that writ petition. So I do not need to challenge that anymore because it is already challenged as has been quoted in that same transfer order. The gradation list.
Whole gradation list is challenged.
I have challenged. I am the counsel in that because of this particular reason that in that gradation list, what they have done.
Whether is it stay?
It is under sub judice. Your Lordship has issued notice on that. And the only point of submission, my Lord, that in that gradation list, this particular illegality has been committed. That is what.
But as long as, in fact, there are judgments of Karnataka High Court which hold quashed gradation list can be acted.
My Lord, on that point, I am not. That point is there.
Therefore, as of now, you are junior.
No, my Lord. That is the point. I'm just drawing Your Lordship.
The gradation list is there. It is not stayed.
My Lord, that's what I'm saying for kind of consideration. The gradation list is a common gradation list which contains people, as I had on an earlier occasion I had submitted, that people having 48% of marks are also included in that gradation.
Whether that is stayed or not,
that is under notice. That's what that much I can say.
Therefore, unless that is stayed, the ranking given in the gradation list has to be operated.
My Lord, that is true. That point means
what best we can do is we can post both these matters together. Since you are going to retire shortly, we can on that ground take up the matter for final disposal.
One submission based on the judgment given by this Honorable Court Division Bench, where it says, my Lord, may kindly come to page number 48.
That a person appointed to junior college cannot be appointed as principal.
This Honorable Court judgment that once somebody is appointed to the substantive post of principal come secretary, he cannot be removed without any proceeding. I was appointed as the principal come secretary. My Lord, and it is said that if the situation arises that the government has to make any transfer or posting, it has to be sensitively done. That's what I would draw my Lord's kind attention.
That is the law.
My Lord. So that is what is my brief submission. That the law is settled by this.
You let him take notice. Let them file a short objection. Then we'll consider.
Short, no, because
even the opposite party number 4 is going to retire on 31/8/2020.
Yeah, that's what.
The petitioner is going to retire on 30/11/2020.
It's not a matter of. It is a matter of principle. It's very short duration.
Principle or ego?
No, principle. Because on that.
No, whether is it principal or principal?
Well, next week I can give notice. Next week this matter can.
Next, what I suggest is, suppose if 31/8 is the office, then they can direct them to place him in that office as a successor. He has to be sensible. Therefore, what I suggest is we will take up this matter in the first week of September itself. By that time, the post becomes All right. We will take it in the last week of August. So that government should not, the opposite parties should not play any mischief to ensure that we not get that also.
That is what they have played.
Let us issue the emergency notice. You are on caveat.
No, I'm
not in caveat. There is no caveats are filed in written petition. Whether there is provision for filing caveats.
Because as I found from the writ petition, my learned is challenging the order which
says that your client is very vigilant.
No, my lords. What happened, my lords, because I shared the same surname with the petitioner, my lord. So while searching with the same, I came up with that he has filed a fresh writ petition.
Issue emergency notice. Learned ASC is requested to accept notice for
Opposite party 1, 2, and 2.
1 and 2.
1 and 2, he can take 3 and 4, my learned friend.
Brother, you
only 4.
Only 4.
3 you can take, he can take 3.
I have
he says he has instruction
for 4 only.
3. So accepts notice.
In fact, my learned friend from government can take for 3.
1 to 3, my
1 to 3.
1 to 3.
1 to 3.
Sub-collector is there.
Right. So appears for OP number 4. First, since petitioner is going to retire
in the month of
November 2025, and OP number 4 is going to lay down the office at the end of this month itself. Come on, call this matter on 29/8.
Your Lordship, please.
29/8. Or 26/8. 26/8.
My lord, kind notice in IA even. Not just notice in IA.
Notice.
My lord, because
both on merits and IA. Issue notice both on merits and IA.
Obligement.
Item 68. Item 68, Your Lordship, I'm praying for an adjournment on behalf of the conducting council.
68. Brother. Please, get the request on.
Your Lordship,
inform the other side.
Your Lordship, other side, the document.
Government.
Your Lordship.
This is my lord. My lord, if that matter can be directed to be brought on fresh admission, or else admission it will not reach on 26th, the previous item.
How can that be? It's once a notice is issued, it comes normatively in that way only.
That's what I was just.
But just try to mention. We may consider. I may consider.
Lordship, this item 68, any day in the next week, because
next week not possible.
Oh, as a Lordship did. Obligatory Lordship.
Item 69. May I please? I'm for the petitioner, my lord. The petitioner has applied one application before the opposite party number 1 for change of their son name, and the middle name inadvertently applied during the application. So opposite party number 3 is rejected by stating with the RTA information addressed to them. Then they come to this honorable court. While tendency of this case, they have complied and they have issued.
They have issued rectified name now.
Yes.
So petition has become infectious.
Yes, madam.
Yes, filed a memo for withdrawal. That is in notice.
Counsel for the petitioner has filed the memo dated 10/7/2025 seeking leave to withdraw the petition. First, memo reads as under. Next one. In view of the above, petition is disposed of as having been withdrawn.
Item 70.
70. Yeah. And for the opinion number 5, my lord.
I have filed a written note of argument.
My lord, here is a case I said the counter from the state government is required, my lord.
Don't worry about counters. They may not file. How can court direct defendant to file written statement? It can take the petitioner can take advantage of that. And government advocate knows the legal position. So we'll accept a few petitions with a face value. Then government will wake up, files review, all these things. What is your case?
My lords, may I pray one time I have money in the morning I have contacted. And
how many years have lapsed now?
2019.
6 years have lapsed.
We have only 1 week, your lordship.
We'll give you, not 1 week. We'll give 2 weeks to you. For a year, 2,000 rupees. We have already set a norm now.
Yes, the matter is very simple. Under
2,000 rupees. If they want.
under Annexure 6, a candidate who has secured less marks than me has been appointed. I have challenged this.
You have filed, you appear for whom?
He is appearing for OP5.
I'm continuing. I have faced this selection procedure. Being selected, I have been issued appointment letter.
Have you filed the
Yes, well, I have counter.
filed the objection?
Yes, I have counter.
If your lordship will see Annexure 5, the merit list, the marks secured by me, vis-a-vis the marks secured by the OP number 5.
For which post it is?
It is
Teacher.
Shiksha Sahayak.
Yes, sir.
Shiksha Sahayak. That is Shiksha Sahayak.
Sahayak, yes.
Shiksha Sahayak.
Page 23, Annexure 5 is the merit list.
Merit list is?
Page 23, Annexure 5.
Where is you are at serial number?
I am at serial number 78 at page 24. Marks secured by me is 184.8783.
84.8783.
83. OP number 5 is at serial number 24, page 23. Marks secured by her is 184.
24, serial number?
24.
Marks is
184.3524. Less than me.
184. 84 point?
0.3524.
Yeah.
This is the only my grievance. I have secured
you have not given appointment.
No.
He is given appointment.
She has been given appointment.
She has been given appointment. Any special consideration like caste, reservation, etc.
SCBC and general. There is, but vacancies unreserved.
All the vacancies are unreserved.
Your lordship will see page 25, last but one column, allotted in category, you are. So those two vacancies are under UR, unreserved.
Here, this is case. Initially, the list was published, and I was not given appointment. In subsequent, two names are there in the second list. In second list, I categorically mentioned in my counter affidavit. Lots of I permitted to read. I will place my lord.
Special list.
Yes,
but in this list, this is the list which has been operated for appointment.
Lots of kindly glance to the averments made in the writ petition.
No, you mean to say this list is not a valid list?
This is a merit list. In merit list, my name was there. My lord, the case is that here I belong to unreserved category. Unreserved category, UR category. He belongs to SC category.
No, UR category.
Only.
Yes.
No, as has been.
That question will not arise because of the category UR.
Category UR, irrespective of any category, merit will be consideration.
My submission is that pursuant to the advertisement, I made application.
Everybody has made application.
Yes, I got selected, and I have joined. Now I have categorically stated in my counter affidavit that by following due process, I have been selected and I have been joined.
No, not due process. It cannot be said to be due process because
the selection is wrong.
Merit is the mantra.
But it is to be settled by the state government.
That too will settle it.
Yes.
We'll set aside the appointment and direct you to make his appointment.
Let a detailed counter affidavit file.
But
unless or until that detailed counter affidavit is filed by the state government who has given me appointment.
No, not necessary.
It's required, my lord.
You have filed away. How can you compel the government to file the objections? What is your right? Can you say that no, government must file a counter affidavit? Where is the rule? They will choose that. No, I don't file it.
Also, kindly glance to my counter affidavit para 6.
Saying
that the averments made in para 6 to 9 of the writ petition, as a matter of fact, a resolution was issued by the Student Master Education. Page 3 of my counter affidavit.
Take down. Petition is allowed.
Page 3, my lord.
On the sole ground that the petitioner in the select list figures at serial number 8, having secured 84.8783 marks, whereas OP number 4 figures at serial number 24, much below the petitioner, having secured less marks, that is 84.3524. First one. Our public employment ordinarily operates on the principle merit is mantra, subject to all just exceptions, into which argued case of the parties does not fit. First one. In the above circumstances, what is to be questioned?
Annexure 6.
A writ of certiorari petition is allowed. The writ of certiorari issues, quashing the appointment of OP number 4 and annexure case 6.
OP number 5. OP number
5 at annexure case 6. No. OP number 4, na?
5, man. OP number 5 is the private part.
First up, a writ of mandamus issues to consider the case of petitioner for the appointment as a Shiksha Sahayak immediately to the vacancy eventually arising because of quashment of appointment of the opening rate. No comes. Court has noted, one sentence, court has noted that the state did not fight its counter, though matter like this warranted one.
My lord, serial number 8, your lordship mentioned, that is 78. 78.
78. My place is 24. He is 78.
No, lordship.
It is the awareness for repetition also.
That has not been arranged in lot of. In place of 8, it is 70 marked.
In place of 8, 70.
70.
Anyway, you are 24.
Yes, I am 24.
70.
I'm in 24, he is in 78. It is the awareness of the right petition, my lord.
It's all right. In the list, where does he figure?
Lordship,
in the list, where do you figure?
70.
Number
78.
70.
List, my name is 24.
24, he figures at 17. Even otherwise, you have secured 84.3524.
Yes.
He has secured 84.8783.
Yes.
What else is required? Maybe some business has happened in securing the appointment order. Why all this has happened?
Oh my lord.
Any?
No instruction, I don't have any.
On that, nobody will give instruction. Who will say that? I have taken so much money to give the appointment.
Must be a mistake because it is mentioned, it is apparent from the list that
things that are happening in your state reminds me of Alice in Wonderland. Have you seen that book, Alice in Wonderland? All abnormal things would happen there. Such things are happening here. Yes. And this is educational field. You have to appoint best of the teachers.
My lord.
Otherwise, the students would be affected.
Sometimes we don't.
Substandard teachers, substandard students. And substandard state it will be. See, Plato's Republic, what he has said. In Plato's Republic and in Gibbon's The Story of Rise and Fall of Roman Empire, he says the Roman Empire fell down not because of war, endemic, pandemic, pestilence, or anything, but the Romans brought their slaves and gave the children on their lap. The slaves could not educate the children. The children of these people started behaving like slaves only. And within 20 years, Roman Empire fell down. That will happen. Yes.
71. My lord, 71 with lot of my lords, we have not filed counter.
How many years? 4 years.
4 years. My lords, may one chance. I will personally say that it will be filed within 2 weeks.
2 weeks. Reluctantly granted at the request of learned ASG. AG to file counter. First time.
72.
May I please, Your Lordship. Lordship, the petitioner is a medium small scale enterprises, my lord, who is solely dependent on the raw material which has been given by the opposite party, my lords. Even in my lordships may kindly see that's a consent letter that was given by them. It's a matter of process. Page 33, ma'am.
Before Your Lordship, I am in VC.
Yes, sir.
Before Your Lordship begins with the case, I have a small submission, Your Lordship.
Yes.
For the self-some relief as made in this writ petition, there is already another writ petition pending, filed by the same petitioner, Your Lordship.
All that matter also is.
Yes, same petitioner.
It may not be available, aware, but let's say,
It is 3195 of 2023.
Call this matter along with WP number 3195 of 2023.
2023.
In the first week of September.
Your Lordship.
23.
Lord, 73, my lord. Similar prayer, my lord. Self-same relief. I have filed one application before this honorable court, which is WPC number 14027.
14027
of 2024, 2024. My lord, my lord. Obliged.
Second week also.
74.
Please, Your Lordship.
Yes, sister.
Presenting on behalf of Mr. Pitamba Panda. The petitioner is serving as an elementary teacher, level 4 graduate teacher. Being a disabled person, he has been denied the promotion.
So you have given representation now. In the seniority list, what is your ranking? In the seniority list, what is your ranking? Ranking of your client?
He's
You will prepare and come back. You will prepare and come back. What's your name?
Meghna Manashwini Mahapat.
Megha. And so argued for some time. She assures that she would come back with more preparation. This court appreciates. This court appreciates. Or in the third week of September. Here, third week of September. Third week of September.
75.
Well, pardon to mention, in this case, I am opposite button number 6. I have not received copy of counter, my lord.
You have not received copy of the counter?
My lord.
No, Lord, state has Lord's, nothing to do because, Your Lordship, this is a matter. The person who was appointed as an untrained teacher was sent for training. While she was on training, her service was terminated. She preferred appeal as per rule. Appeal was allowed. The managing committee preferred a writ application that was dismissed, and the order of this appellate order court was confirmed. Thereafter, the direction was that another writ application filed by the self-same petitioner seeking a direction since her termination has been set aside. Kindly give a direction to the state to allow her to get the aid. What this honorable court did, this honorable court directed the petitioner to approach the state education tribunal. Yes. Lords, the state education tribunal, instead of deciding relieve the granting deed in favor of the petitioner, rejected the claim of the only on the ground she is not senior. Lord, what happens during the pendency of appeal? Lords, the managing committee appointed a stranger hastily. Lord,
repeat last sentence.
Lords, when the appeal was pending before the director and the granted case was pending with the state education tribunal, somebody was put in against my post. I was not given any reinstatement in spite of the.
After reinstatement, you only become senior.
Yes. No, because I have been.
No, I'm asking you.
Yes.
Is it your?
No, Lord, since my service was terminated because I was not an trained graduate.
You were terminated on which date?
Lord, Lordship, kindly see page 10/194.
You joined when?
Lord, I joined on 15/191.
Joined as?
Joined assistant teacher because at the relevant point of time, the trained teachers were not available. Therefore, untrained teachers who applies for the post pursuant to the advertisement, they were appointed. I was appointed. But because taking aid of one letter from the board secondary education.
On 10/194, you were removed.
Yes.
So that removal was set aside by the tribunal.
Right. Director secondary education on 19/8/96.
No, you said tribunal.
Plus, tribunal subsequently thereafter with regard to approval of the post.
Okay. The director set aside.
Yes, my lords.
He set aside this
order of termination, directed them to take back the petitioner. Page 23.
It's a departmental appeal.
Departmental appeal, my lords.
That was dated?
No, that is dated
when?
19/8/96. 19/8/1996. 19/8/96.
For reinstatement.
For reinstatement. The said order was challenged before this Hon'Ble Court.
In WP number?
OJC number.
That is management challenge in that.
OJC number 1933 of 98.
OJS number.
OJC, Odisha.
Original jurisdiction case.
Sorry, original jurisdiction case.
OJC number.
OJC, original jurisdiction case.
Number?
No, sir. 1933 of 98.
That was dismissed on?
Dismissed on 13/12/2007.
On that, no appeal?
No
appeal was?
No appeal.
Therefore, you came to be reinstated?
I was not given a reinstatement.
Despite this order? And then you approached this court?
No, lords. Along with that, I had also filed a writ application. After setting aside my order of termination, I approached this Hon'Ble Court seeking a direction. Since my order of termination was set aside, kindly give direction to the departments to approve my post. That writ application was OJC number 15,689 of 97.
Your OJC number?
OJC number 15,689 of 97.
Wherein you had sought for approval of the post. And what they said, go to the tribunal.
Both the writ applications were taken together and order was passed on the same date.
Both the writ petition. Which writ petition?
Lords, my writ application as well as the writ application filed by the
OJC number.
OJC number.
OJC is also writ petition only.
Nomenclature was. Earlier it was original jurisdiction cases.
It became WPC. Okay. Relegated to tribunal.
Yes, my lords.
Tribunal says Since you are not senior, we will not approve.
The person who intervened in my service, he became the senior. I was declared a junior.
In your vacancy, after your removal,
My lord.
Whether anybody was appointed.
Lords, they said that he was appointed, but no advertise and nothing else. But he was given a chance. Lords, appointed against my post.
That would be list pendants, subject to outcome of your challenge.
My lords. Thereafter, my lords,
Now, when the order of the tribunal?
Tribunal order is 31st 3, 2010.
That is appeal before the tribunal.
No, Lord. GIA case number 84 of 2008.
GIA means?
Granted case, Lords.
Is 34?
84 of 2008.
So you have 14 years you have been fighting.
Yes.
2008 it was.
No, still I am also waiting and
Still
waiting,
you are
Lords.
You are like Alexander.
Lords.
That decided on, dismissed on?
Dismissed on 31st March 2010.
Thereafter what happened?
Lords, I preferred appeal, Lords, before the Supreme Court. And I lost. I preferred appeal before the Honorable Supreme Court. I lost.
GIA case 84 of 2008
My lords.
was by you.
My lord.
That in that what you had challenged?
Lords, I challenge that order of the
tribunal which said your post cannot be approved.
Yes, Millers, I'm sorry. After the order of the State Education Tribunal, I preferred FAO appeal before this Honorable Court.
FAO. FAO. What happened to FAO?
FAO was rejected.
And went to Supreme Court.
Supreme Court.
That also rejected.
Rejected.
And now what we should do?
Millers, thereafter, I Millers preferred a review. That was also I lost. In the OJC order, what the Honorable High Court, while disposed of the FAO, confirming the order of the Departmental Appeals order, directed that I should be adjusted against a TG post.
TG.
Trained graduate post.
Trained graduate post.
Yes, Lords.
Then they gave it to you.
No, Lords. They didn't give it to me. Then, since the order was there to adjust me, I preferred a GA, made representation that this was the finding of the court. Please give me appointment any school if there is no vacancy in the particular school. That was not considered, though I filed another GIA case 24 of 2016.
What happened?
In that case, the tribunal directed the authorities to consider a case and give appointment any school, nearby school or in that particular school if there is a vacancy. That was not considered.
That order was made on?
On, my lords, 15th February 2020.
If I write the judgment with all these facts, I cannot attend today's function at the evening at all.
Your Lordship's welcome meeting.
No, I will not stand on this.
15 to 2020, they again consider.
Mellors. Thereafter, that was not considered. I preferred a writ application before this Honorable Court, seeking a direction that the petitioner's grievance may be considered because
WP number?
Lords, WP number
4746 of 2020-22.
What the court said?
Honorable Court directed the authorities to consider. The authority considered my case, that is Annexure 9, page 13 for 2021.
That this code upon consider your case for what?
Let's do give me appointment in that school or any nearby school. The order of the deputy director, the authority who was in charge of that directorate, he has made everything clear that what fraud has been committed, how the records have been manipulated, how the illegality has been meted out to me. That is very clear order by the deputy director under Annexure 9, page 46.
Go to 46. Now, what he said?
He says illegality has been committed, injustice has been done to her, so she may be allowed to continue any school wherever vacancy is there.
That what happened?
Till that not has been accident. Lords, again I filed, Lords, because this was not considered, I filed a contempt application. In the contempt application, that was not considered. Again, time was granted, 1 month more time. If you not consider, you please consider the same within 1 month.
In contempt matter, time is given for compliance.
No, here it is given.
It is first, second,
last, second, third, this, so on and so forth. This is given here.
Then what happened?
Lords, in the order itself, Lords, while the matter is so pending with the authority, they rejected my representation, saying because of the since Supreme Court rejected, review rejected, all that they rejected and did not consider or did not whisper anything about the director's order to give me appointment in any school or any nearby school.
What all these matters have been considered by the director?
Lords, director, Your Lordship, kindly, it will take some time. Lords, observation 2, Your Lordship, kindly see page 47. The very first appointment, Lords, with Your Lordship's permission, the very first appointment of the petitioner from 1991 thus got revalidated in the post of TGT Arts with effect from 1980-96. 1980-96.
Allowing the appeal.
Yes, Lords. The school was unaided then. Though the director's order was passed in 1996, the school managing committee did not comply with the decision apparently to keep the petitioner outside admissible yardstick post. The managing committee filed a case after 2 years before the High Court in the OJC number so and this case continued for 9 years and was decided on 13/12/2007. The Honorable High Court upheld the order of the director and MC lost the case, but MC did not comply the decision of Honorable High Court. Then objection
consider.
Hello.
And they did not consider, contempt court gave time to consider.
Lords.
And they rejected.
They rejected. Lords, second observation 3. Managing committee for the second time defied the order of another superior legal authority. That is the version of the director himself, who was in charge, deputy director who was in charge of the director, and pursuant to direction of this Honorable Court, he considered. Lords,
he considered and rejected.
No. Allowed. Directed them to.
That is page 47.
37, yes.
Yeah.
That prior to 1998, Purnima Swami had filed OJC number so claiming seniority over others as per date of initial appointment in 1991. This OJC was heard and finalized on same 13/12/2007 with OJC so filed by managing committee. While the OJC number 1933/98, the managing committee lost, making director's order of setting aside the termination order of Purnima Swami affirmed in OJC so filed by Purnima Swami regarding seniority was transferred to SET. By then, the school was already notified for GIA under 10 girls. In ACT, the matter was registered as GI case so and it was decided on 31/3/2010. The order went against the petitioner Purnima Swain. The tribunal declined to allow seniority, ignoring the date of passing BD later. Purnima Swain challenged the order learned tribunal by filing FO 186/2010 before the High Court. It was decided on 12/9/2013. 14 months after this was decided before the High Court. She lost after dismissal of FO. She filed SLP number so and so, followed by
Pichu Reddy is of deputy director.
Lords,
Who was in charge of director.
Then your lordship kindly.
Then director did not agree with that. Director rejected.
No, director allowed. Lords, kindly see last consider
22/12/2023.
Lords, yes. Lords, kindly see considered view. Last paragraph. The disposal order of DO needs a little refinement because the prayer of GIA case number 24/2016 and GIA case 84/2000 are different. The DO has discussed the prayer in GIA case number so and so and follow up FO and SLP. After Director's Office Order so and so 1996, termination order issued by the MC became legally untenable. The Director's decision has also been affirmed by the High Court. If she is to get back to her own post as decided by the Director, then it will be deemed that she has been appointed from 1991. As a pre-93 appointee, she is entitled to coverage under ratio of judgment Vivekananda Das case. Moreover, she was already trained by the time the school entered into GIA fold. The managing committee has committed mistake. You'll also mark it. The managing committee has committed mistake of appointing 3 persons in 2 TGT arts posts. Later on, the managing committee has sided with 1 person and made a petitioner scapegoat. The staff approval of 1 TGT art post should not have been made by DO till a decision is not taken on initial termination of the petitioner, which was later set aside by the Director as appellate authority.
That too after High Court direction to consider.
Yes, in view of the above fact, petitioner has been made to suffer because of mischievous intention of managing committee. Now that she has gone past the age of new job, there is observation of High Court in the FO order to consider her case in the event section is created. SAT has in the present case given liberty to opposite party to consider her adjustment against a vacant post in Khordha district. It may be so considered and order passed.
The director has approved the draft before issue.
Yes.
Who is that director? He is only deputy director.
Director.
It is approved by the director.
In the meanwhile, director joined, therefore he placed the order before director for approval. The director approved this. That has not been carried out till then.
But next order you kindly see. There is an order by the director himself now.
This is the under challenge. This is
what, brother? One director allows the prayer and the other director, succeeding director, rejects the prayer.
My lords, deputy director is the deputy. I am not there, my lords. I am not there. My lords, that order, the deputy director's order, which was placed by my friend.
But it is approved by the director.
It was challenged in High Court by the petitioner. No. In WPC number 4746 of 2020-22. In that WPC, this Honorable Court directed the Secretary, Commissioner from Secretary to consider the case. It was considered and order was passed by the Annexure 10, order dated 26/12/2023, my lords. Saying that is not entitled to. And my lords, 26/12/2023, Annexure 10, my lord.
That is impugned before this one.
That is joint secretary to government.
My lord, secretary has signed. Next page, joint secretary has communicated it.
This is commissioner's order.
My lords. My lords, what I humbly submit, my lords, the director's order allowing the appeal of the petition was challenged by both the parties before this honorable court in OJCs.
Correct. Common order
was passed to approach the tribunal, my lords. Tribunal found that he is not entitled to.
It is for approval of the post.
My lords. Tribunal's order is that he is not entitled. Then it was carried in appeal, my lords. Then it was carried to Supreme Court. That order attains finality. That has not been changed till today. It was not reviewed.
But a lot of
and my lord, so much of complications.
No,
lot of cases.
Injustice has been done.
Your lordship may fix to we should make a date chart for convenience.
Once I hear this side or that,
my lord. Well, lord, so we have filed counter. All the parties, opposite parties have filed 2 counter, 1, 2, 3, 4.
How many years of fighting?
No, here it has
15/1/91 she joined the post. 10/1/94 removal.
My lord.
Director allowed on 19/8/1996.
My lord.
Then management's OJC, OJC also.
2 OJCs.
2 OJCs came to be clubbed together and common order came.
13/12/2007.
The management's OJC is rejected against that order.
My lords, the common order was passed to because...
no, not common order. 2 orders were passed. Your matter was rejected. In my case, a different order was passed.
In the OJC 15689 of 97.
My lord.
That's your order, brother.
Lord, sir,
OJC 15689 of 97.
Lord, sir, date is same, but orders
are different orders.
My lords, my counter, your lordship kindly see page 5. May I place, my lords? It is submitted that the petitioner filed OJC number 15689 of 1997 seeking direction for approval of her service and for payment of financial benefits granted that. The Honorable High Court by order dated 13/12/2007 transferred the writ petition to Orissa Education Tribunal Bhubaneswar for disposal in accordance with law. After transfer, it was transferred. After transfer of the writ petition, the learned tribunal renumbered it thus. The learned its judgment dated 31/3/2010.
But the direction to reinstate her in service, that remains intact. That has not been set aside by any court.
That, my lords, that order was challenged in this OJC.
And they lost it.
That they have not stated that. It was only stated that by order dated the transferred writ petition was transferred.
No, the order of the director being the appellate authority, appeal came to be allowed on 19/8/1996 for reinstatement.
My lord.
That order is not disturbed.
That order was challenged in OJC.
And management lost the OJC.
My lord, management lost
OJC number 1933 of 98.
That order is not here.
Yes, page 27 and 28. Annexer is, that is the annexer.
Go to 27, 20.
Annexer 6.
Now, your order to reinstate you, that order is not disturbed by any court.
No, they have
that
not
remained intact.
Still, versus my instruction, as on today, the school is running with only 2 teachers. Posts are lying vacancies.
No, that's all right. But somehow some porters have worked against this lady. The reinstatement order remains intact throughout. Nobody disturbed it. And challenge of the management to the same ended in futility. So that order attained finality.
My lords, page 27, your lordship.
27?
My lords.
Go to 27.
My lords. This is OJC preferred by management, my lords.
This they lost. Under such circumstances, there is nothing to interfere with the order and exonerate, and accordingly, writ petition is dismissed. So it got the seal of this court. Whether post should be...
My lords, in other words, the impugned order doesn't suffer from any illegality or termination of services of the opposite party, number 3.
No, reinstatement order was challenged.
Well,
Reinstatement order made by the director being the appellate authority was challenged by the management in OJC number 1933 of 1998. That has been negative.
And my lords, their claim in OJC.
No, that was for approval of the post.
Yes, my lords. That was
that
not.
Approval you need not grant. But reinstatement has to happen.
My lords, unless it is approved, my lords, the rules requires approval, my lords.
First is reinstatement, then approval. First is reinstatement, then approval.
Approval is a post facto action. Once you make appointment, then question of approval and other things. That's how Apex Court has interpreted that question, which is that judgment. Take out what is meant by approval by the Supreme Court under various legislation Supreme Court considered. The Surendra Malik's Supreme Court and words and phrases. Can anybody Google out? Approval is a post facto action.
The honorable courts, our High Court has a direct.
Where is that?
Lots of volume.
In the library. Now I have to run to the library.
Lots of volume 49 CLT, page 443, Honorable Justice B.L. Hansare was there. His lordships have dictated, gave that decision. Lords, your lordship may kindly see.
There appears to be lot of trouble this lady is put to. Continuously, like Ahalyabai Holkar, she has been waging legal battle throughout. Though there is an order, the rest of the things you leave. Whether should be granted approval, etc., is another thing. But whatever status she had, in that status she should have been continued because of reinstatement order.
My lords, before the tribunal, the petitioner's case was that for direction to approval.
Yeah, that is rejected.
That was rejected.
Yes, yes.
So impliedly, that rejection order
will dilute the reinstatement order. How?
My lords, reinstatement without approval has nothing to.
Which rule says?
Rule, please.
Show that.
Go reinstatement, then approval.
Reinstatement it is as good as appointment and approval.
Correct.
Unless.
Yes. From the date of removal. Unless the authority says otherwise.
Well.
No, so on the question of reinstatement, after the judgment of the Honorable Supreme Court, Sandeep Kumar versus the district.
Others need not wait. I need not mention also. Your wherever interim orders are there, they will be continued. And wherever interim orders are there, you continue that. And put them in the second week of October. Do not mention, do not disturb, because I am in the midst of hearing of this.
Private school.
We have said, don't mention, we are in the mid of the hearing matter. Brother, which rule says the reinstatement requires approval?
Not reinstatement, post itself requires approval.
For appointment, approval is required. Which is the rule?
I'm sorry,
Nowhere such a rule is there.
I should assist.
Yeah, nowhere.
Your Lordship, grant me little time tomorrow.
I have heard this matter so long.
No, I'm sorry.
Now she is 56. Now running 56.
You should have got a stay of aging also. Anyway, she has got. Where is that rule which say the appointment itself requires approval?
Appointment for getting granting it or granting it requires approval of director.
Department.
That was
the reinstatement where the liability would be of the institution itself.
My lord.
Who appears for the institution?
Inspector school himself.
You are
management, private management.
No, nowadays there is no private management. Inspector school is in charge. Say private.
Not private management.
No.
It is management.
All over the state. Inspector schools are where the schools have got the aid. Inspector schools are in charge of management.
Management is inspector.
Managing committee school is not there. Inspector is in charge of managing committees.
With effect from which day?
Recently,
earlier there was management.
Yes, please.
There was private managements.
It's a private school.
Private, yes, my lord. Subsequently, it gets granting aid.
Subsequently, it is admitted to granting aid. On which date it is admitted to granting aid?
Lord, it is taken to granting aid 98 lords. Lord, that has been mentioned. You will also kindly the order itself, page 46. From 94, the coach, it is 98 lords. That is clearly mentioned. 98.
98. Take down. This case has a checkered history. First off, it is a saga of a lady relentlessly waging the legal battles, one after another. Come on, not being deterred by the victory that eluded her. First off, next paragraph. Brief fact matrix. Petitioner joined the OP school as assistant teacher with effect from 15/1/1991 pursuant to a particular advertisement to which response from the job market was bleak. First off, to her bad luck, she was removed from service unceremoniously with effect from 10/1/1994. Basanto, when she was on deputation for training. First, A, B, C, D. She preferred departmental appeals, which the director of what? Secondary education favored while order dated 19/8/1996 with a direction to reinstate her in service as before. First off, management's challenge to director's order in OJC number 1933 of 1998 was negatived by this court. Negatived by this court. This is not nonsense. Negatived by this court. Wide order dated 13/12/2007. First up. Next paragraph. In the meanwhile, petitioner had filed OJC 15689 of 1997 seeking a direction for the approval of her post in the school. First up, a coordinate bench of this court, while order dated 13/12/2007, correct?
Well,
relegated the petitioner to tribunal. First up. What tribunal did, brother?
the tribunal dismissed his application, my lords.
The tribunal did not favor her claim. Why order dated?
That's
Tribunal's order.
Mm, 31/3/2000. 51/3/2010. My lords, two cases, my lord.
no, that is
Two cases, my lord.
31st March.
31/3/2010.
Yes.
31/3/2000. What you have written? Did not favor her claim. No, brother. It is not 31/3.
No, my lord.
GIA it is.
Yes, that is the GI order.
No, tribunal's order.
That is the GI order, lords. Tribunal lords will kindly see page 30. That is the honorable court's
Claim in GIA number 80, J case number 84 of 2008. Wide order dated 31/3/2010. First up. Which is that no, any direction was given to give you TG post.
lords. No, the tribunal rejected my claim.
Then the GIA 24 of 2016 against what?
Lords,
No, against this rejection you made WP. FAO. Petitioner's FAO number, tell that number.
Lords, that is 186 of 2010.
186 of 2010 came to be negatived by a coordinate bench of this court. Wide order dated
12/9/2013.
12/9/2013. First off, Petitioners further challenge in SLP number, correct?
Yes, Minister.
Give the SLP number.
32733 of 2013.
Written down. Also came to be, also met the same fate. First off, all this is about approval of the post in question and had nothing to do with the order of reinstatement.
My Lordship.
First off. Next paragraph. Brother, you filed GIA 24 of 2016 for what purpose?
Lord, to carry out the order of this honorable court passed in the FAO to give me, to adjust me in the post. That was there.
In FAO?
Yes, my lord.
In FAO was dismissed?
Dismissed with a, my claim for approval are dismissed, but the direction to adjust me in the post of TGT. That was there.
May interfere. My lords, his claim was rejected by this honorable court in FAO on the ground that the appellant was not a trained graduate by the time she was initially appointed by the managing committee.
Yes.
But there is a direction to consider her for TG post. Read 2 lines in that order.
Lords, and the appellant should be considered to be a teacher under the management of school institution and is not entitled to granted.
Read again.
Again, the appellant should be considered to be a teacher under the management of the school.
Next paragraph. While negativing the OJC, FAO, FAO number?
186 of 2010.
186 of 2010, learned judge of this court observed that the petitioner should be considered for appointment to the post of
to be a teacher
to be a teacher in the private school, private unaided school.
No, teacher under the management of the school.
Under the management of the school in question. Although she was not entitled to grant of approval for want of educational qualification. First off, petitioner filed GIA 24/2016 seeking implementation of learned single judge's order, this order, which came to be negative on 15/2/2020, which came to be disposed of on 15/2/2020, with a direction to consider her candidature, correct?
Yes, for her appointment.
For candidature for appointment in terms of the said observation. First off.
My Lordship,
That did not happen.
That did not happen. Till date also.
That did not happen. And eventually, petitioner moved WP 4746 of 2022. Correct?
Yes.
In that what happened?
Direction was to the state to consider keeping in view the observation of the deputy director.
Wherein, which came to be disposed of, wide order dated?
Order dated 12/5/2023.
12/5/2023 for consideration of his candidature for appointment in one of the 2 vacancies. Correct? Is it correct?
To consider the representation.
Huh?
Representation of the petition.
Let's say this is the order.
Give that.
Education.
To consider her representation. Consider. In that representation, what you had sought for?
They did not consider it.
No. What was your prayer in the representation?
Lords, my prayer was consider my representation, keeping in view, Lords, Deputy Director's observation. That annexer 9.
To consider her representation in the light of Deputy Director's order. Recommendation.
To the Joint Secretary dated 13/4/2021.
Dated 13/4/2021.
Annexer 9.
At Annexer 9. No. First off. However, the consideration did not yield any fruit to the petitioner. The representation having been rejected. Why the order dated?
26/12/2023.
26/12/2023. Made by the director.
Commission.
Made by the
Secretary. Secretary.
First off. That is the subject matter of challenge here. That happens to be the subject matter of challenge in this petition. Next paragraph. Learned counsel for the petitioner, main paragraph, vehemently argues that regardless of entitlement to approval to the post in question, the reinstatement order which his client has secured at the hands of the director on 1996 has remained unimplemented throughout, and that would not augur well to the rule of law and to the interest of public service. The statutory orders which have attained finality after challenge have to be implemented. And that having not happened, by virtue of impugned order of the commissioner, this code should come to the aid of petitioner. First off. Next paragraph. Learned AGA appearing for the OPs resists the petition, contending that although the petitioner has waged too many legal battles, she did not emerge victorious. Her SLP number. Tell the number.
32733.
32733 of 2013 at the hands of the apex court of the country, having failed. First up, he also submits that the question of reinstatement would not arise in the absence of rejection of petitioner's claim for approval of the post at the hands of competent authority. First up, so contending, he seeks, kindly be seated. Brother, kindly be seated. So contending, he seeks dismissal of the petition. First up. Next paragraph. Having heard learned counsel for the petition parties and having perused the petition papers, this court is inclined to grant a limited indulgence in the matter as under and for the following reasons. 1. The initial appointment of the petitioner as an assistant teacher with effect from 10/1/1994 is not in dispute. She was sent for training to make value addition, and that during the period of training, she came to be removed from the post, wide order dated 10/1/1994, that 15/1/91 initial appointment, 15/1/91. Came to be removed from the, unceremoniously removed from the post, wide order dated 10/1/1994. First off, her appeal against the removal succeeded. The director, setting aside the removal, wide order dated 19/8/1996 and 96, coupled with a direction for reinstatement in service. First one. Learned counsel for the petitioner is right in telling that this statutory order, on being challenged by the then management of the school in OGC number 1933 of 1998, attained finality on dismissal, on its dismissal. First of all, this adds additional strength to the submission of learned counsel for the petitioner. Next one, kindly be seated.
I want to point out one thing at page 29.
Double face. That is double face. That is repeated in the next. Page 28 is equal to page 20.
29. My lords, kindly see the petition, OJC filed by the petitioner. My lords, I am placing 2 lines. Petitioner who claims to be assistant teacher
of OJC of 15689 of 97.
My lords, who claims to be assistant teacher of Gadi Brahma High School, Jagdishpur in the district of Jagannathpur in the district of Khordha, has filed this writ petition for approval of her service and for payment of consequential financial benefits under the granted fold.
Correct. That is rejected.
My lord.
Correct.
That is adjudicated in GIA. My
Correct.
lord.
That is rejected. What you have written? Petition. First. Next one. The vehement contention of learned AGA that petitioners OJC 15689 of 1997 seeking approval of the post in question was negative by this court.
My lords, that claim was transferred to the tribunal.
Only.
My lord.
Only
Subordinate bench.
My
directed me
One second.
to approach the tribunal.
Came to be negative. Why the order dated?
13/12/2007.
13/12/2007 is only a half truth. The main prayer was not granted is true. First one. However, petitioner was permitted to make an appropriate representation to the competent authority, which he did. First one. That was the subject matter of GIA case number 84/2008, which had sought to enforce observation of the learned single judge made in his OJC number 156/89.
Division bench, my lords. That
Division
was the
bench.
division.
By the division bench instead of by the division bench to continue him in service of the school. Sans approval, without approval. Approval. First time. It is strange that the said GIA came to be dismissed while order dated 31/3/2010. Against that, what did you do?
Lords, against that order, Lords, I made a representation.
My lords, FAO 186 of 2010 was filed.
FAO
186 of 2010. And by judgment.
Now what it said?
By judgment dated 12/9/2013, the FAO was rejected.
Is it true? The order dated 31/3/2010 and the division bench of this court,
single
FAO is
appointed bench of this court negatived the FAO. Any observation in that?
No, ma'am.
Appointment as a teacher.
FAO wide order dated 12/9/2013 is true. Where is that? Read that observation.
Lordship said.
My lords, it is
page
FAO
36. Go to 36.
The appellant should be considered to be a teacher under the management of the school. The appellant should be considered to be a teacher.
Paragraph?
Paragraph 7, page 35.
My lords, it is clear dismissal, my lord.
No,
para 8, your lordship finds. Page 37. The views expressed by the Education Tribunal in impugned judgment cannot be faulted with, and no.
So far as that is concerned, all right. But the observation that he should be treated as a teacher, that remains intact.
My lords.
That is. No observation, my lord. It is clear dismissal. Page 37, your lordship.
No, Lord, page 35. Don't please don't suppress.
Suppress it is not a question.
Don't speak like that. But he's a government advocate. He's entitled to say whatever.
No, Lord, the correct thing I mean.
Don't say that. How you should appreciate him. He wants to protect the interests of the government. Nowadays, government is destitute at the hands of many government advocates. First, the coordinate judge at para 7 observed inverse. The respondent number 5 having acquired training qualification much prior to the appellant, the appellant cannot be considered to be senior to the respondent number 5 as the yardstick did not permit for adjustment of 5th trained graduate teacher, and the appellant should be considered to be a teacher under the management of the school, and he is not entitled to grant in aid for the present till new sections are opened in the school requiring extra trained graduate. First off, the inverse complete. This also strengthens case of the petitioner to an extent. The denial of approval to the post in question notwithstanding. First term. Next paragraph. How many vacancies are there now?
No, sir. Now 2 teachers are only 2 teachers instead of 5 teachers, including headmaster.
Where have you stated it in the petition?
Present situation I have taken.
Next paragraph. Learned counsel for the petitioner submits, and there is no reason to doubt that version, that presently the affairs of the school are managed by the inspector of education, the tenure of the governing council having expired.
Inspector post is not there.
DO. District Education Officer, the tenure of the managing committee having expired, and that there is a dearth of hands in the school, and therefore, keeping in view the little victory which she has secured in some litigations, especially the order of reinstatement dated 1996 having attained finality, petitioner should be accommodated, becomes acceptable. First off, it is told at the bar that the school in question is admitted to grant in aid way back in the year 1998, and therefore it partakes the character of Article 12 entity in the light of apex court decision in Ajay Hasia versus Khalid Mujib Suravardi. 81 Supreme Court, just look into that. First one. He is right in telling the court that an Article 12 entity has to conduct itself as a model employer as constitutionally ordained, while Bhupendranath Hazarika versus State of Assam. First up. Next paragraph. Courts in general and constitutional courts in particular are there to maintain the practical rights of the citizens. They cannot turn away worthy causes by quoting some jurisprudential theories. First up, it is relevant to quote what Justice Oliver Wendell Holmes of US Supreme Court said in so and so, so and so. Next paragraph. In the above circumstances, this petition succeeds in part. Semicolon. The impugned order of the commissioner having been quashed by issuance of writ of certiorari, the writ of mandamus issues to the respondents to accommodate the petitioner in one of the vacancies in the post of assistant teacher in the 5th respondent school forthwith. And report compliance to the Registrar General of this court within an outer limit of 6 weeks.
My lords, one problem will arise. Now they will claim, she will claim all financial benefits and other things which was negatived by the court.
It is made clear that the petitioner shall not be entitled to any financial benefits for the time spent in the legal battles. But notional service has to be given. Otherwise, she will not get anything at all. She is 56.
Notional benefit.
However, for the purpose of pension and other terminal benefits, I'll make some.
My lords, so that will may create obstructions.
What is mistake with her?
My lords, sympathy is I bow down. But the problem is that government will be burdened by.
Leave it up to that one. For any other grievance, liberty is reserved to the petitioner to work out in appropriate proceeding.
From the date the appeal was argued for notional benefits, financial benefit I am not. This service benefit, financial benefit I don't press for that. That should be counted towards my.
It will be stayed in no time. Understand, at least whatever little you get, you should get.
My lord. We should not
something. I must with my begging bowl to get.
Next of the matter, next week, my lord.